House will come to order. Members, we're going to do a couple more introductions here before we proceed on to our committee of the whole. First bill for our consideration is House Bill 258. Reading clerk will read the bill.
House Bill 258, sponsored by House Appropriations.
First reading of the bill.
State-funded capital construction.
House Bill 258 will be assigned to our committee number 2, Appropriations. Next bill for our consideration will be House Bill 259.
House Bill 259, sponsored by House Appropriations.
First reading of the bill.
Supplemental K-12 school facilities, Appropriations 2.
House Bill 259 will be assigned also to our committee number 2, Appropriations. Okay, now. We're going to move into Mr. Majority Floor Leader.
Thank you, Mr. Speaker. Mr. Speaker, I move that the body resolve itself into the committee of the whole, and the first 5 bills, we have a lot more than this, but the first 5 bills will be House Bill 47, 46, 80, 18, and 172.
You have heard the motion. All those in favor signify by saying aye. Those opposed? No. Motion carries. Representative Banks.
Keep your chair warm.
Oh, I got it warmed up, thought out. Yeah, you're fine. This is the script. This is the script right over here. You're going to have general file. There's your script. It's all general file.
Committee of the Whole will please come to order. Is this the list? Okay. The first bill for our consideration is House Bill 47. The reading clerk will read the bill.
House Bill 47, sponsored by Blockchain, Secretary of State, expedited filings. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 47. Secretary of State, expedited filings. Respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Campbell, Heiner, Knapp, Larson, Lawley, Riggins, Schmid, Tarver, Weber. Representative Heiner, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred House Bill 47, Secretary of State, expedited filings. Respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Alamand, Angelos, Bear, Haroldson, Pendergraph, Sherwood, Smith. Representative Bear, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Heiner?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that bill number 47 do pass, and I further move the adoption of the standing committee amendment. For explanation of this bill, I turn it over to the good representative that sang to us on the first day of session.
Representative Singh.
Thank you, Mr. Chairman. Folks, this bill is it's a good little bill, a simple little bill. It's a Secretary of State expedited filings, and what it does is it creates another option for business owners in the state of Wyoming to file with the Secretary of State. If you look on the second page there, it says that an expedited filing, that there would be a maximum of $5,000 that the Secretary of State could charge for this new service. And then with the amendment that was moved in, coming from the Appropriations Committee, it attaches the funding for one full-time position for the Secretary of State. The provisions of the amendment include that if we were to fully fund the requests by the Secretary of State in our supplemental budget, that this amendment would go away and that would be included in their standard budget. And so ultimately, folks, this bill is to create more options for businesses if they want to have a speedy filing period for something such as a merger where something needs to get done in a speedy way. We're one of the only states that has a 15-day filing deadline. And so this also has the support of the good agency affiliated with it. And I stand for questions.
Questions on the amendment? Representative Washut.
Not on the amendment, I'll come back.
Questions on the amendment? Representative Yin.
Thank you, Mr. Chairman. So members, the appropriations, we're talking about the amendment, right? So we're talking about an extra position for the Secretary of State's office. We actually had this discussion in corporations during the interim on whether the Secretary of State really needed an extra position or not to execute this. There was some belief that it would create more work for the Secretary of State, but I think there was a lot of, how would I describe it? Resistance to the idea that the Secretary of State necessarily needed the extra position to get it done. And the thought was that if the workload suddenly exploded for whatever reason, we could come back in the next budget and really make sure that they had that position. But I think at the moment, you know, as this ramps up and people realize that we have this expedited filing process, I'm not sure we actually need the extra position right now for that. Thank you, Mr. Chairman.
Representative Bear.
Thank you, Mr. Chairman. Have spoken to the executive number 2 about this issue, which was brought up by the previous speaker, and we are currently running way close to that 15-day deadline. So there is currently an employee shortage. So we as a body are putting basically an unfunded mandate upon that agency by saying we want to have this additional service, which I think is a great service. Our biggest competitor, the Northeast, in this type of service is using this very same methodology. They do not have a 15-day requirement. In fact, they don't have a 30-day. They have no requirement whatsoever. And they have a lengthy turnaround time for these filings, whereas we are restricted statutorily to 15 days. So our personnel are currently being used basically to the limit to just stay under that 15-day limit. We add this additional service, there is definitely a need for an additional person. So this type of person that we put into this bill and this amendment is the third tier. So this is more of a supervisor, because the kind of filings that are going to be brought that need to be expedited are not simple filings. You put in a simple filing, you do almost all of it online, and it can be done very quickly. Our state has a great reputation, and that's why we are about to overtake the state that does the most. We actually do more filings per capita than any other state in the nation. We are now basically the place to file your business. But this will draw a lot more business on the more complicated filings. So the position really is required, necessary, and I ask for your aye vote on the amendment.
Chairman Heiner.
Thank you, Mr. Chairman. Just to reiterate what the last speaker said, you know, the representative from the Tall Mountains mentioned that we had this conversation last year, and I remember that conversation. Let's see if it ramps up, and it has ramped up. We're number 2 in the nation now for these type of filings. And this is one of the only departments within our state that is creating revenue. Tens of millions of dollars a year coming from these filings and what's going on in that office. So we talked about what would happen if the business did ramp up. Now it has ramped up. So let's stand behind what we said a year ago. Thank you.
Representative Clauston.
Thank you, Mr. Chair. On and for this amendment, I think making Wyoming the friendliest business state in the union is important. I think that's one of our goals, and this is a step towards accomplishing that goal. Thank you.
Representative Nicholas.
Thank you, Mr. Chairman. So I'm on and against the amendment, ladies and gentlemen, and so I think a little background is probably important. For the last 2 years, the number 2 executive has asked for one or the other, either 3 new employees or an updated computer system. And for those, the last 2 years, we denied both of those requests. In your past appropriations committee, just only about 2 months ago, recommended that we provide the updated computer system, because that computer system will basically perform the task, multiple tasks of those 3 employees, and over the long run would be a better expense because that upgrade is needed. So I would regularly suggest that we deny this amendment and figure out if we're going to either give him 3 new employees as he's at, because there are other bills that come out where he's asking for employees besides this one, and see if the computer system is more important. It's a little costly, but having go out for bid for it, I think roughly it's around $3.5 million to increase improve the computer system. And to me, that makes more sense than adding employees, if we can do it. So on and against the amendment.
Representative Filer.
Thank you, Mr. Chairman. I am definitely, I think I'm on and for this amendment. One thing I would, though, is I can remember a while back that whenever we used to have new positions, or if a department asked for new positions, that we would ask after a couple years, maybe a report to make sure that those positions were actually a necessity or needed after those first couple of years. So maybe another amendment or something to bring up later, but on and for it.
Representative Ottman.
Thank you, Mr. Speaker. On and for this amendment, what I will say is, yes, we have been asked to appropriate money for a new computer system. As we look at a lot of our offices throughout the state, a lot of them in the courts and different places have asked for updates as things are getting to be more efficient. And as was stated also, our filings are unbelievable. This office, number 2, is one or the only office really that makes an income. The additional work that this would provide for, this ask, is we're talking about a whole new scheme of things, how to work with people to expedite their filings and not make them wait. We've done that in our court system with a new courthouse and things that was put in place to go along with the blockchain. We did that a couple years before it has finally come to the point where it looks like it may be advantageous to have it. So I would just say, as this office continues to work on a skeleton crew and provide exceptional business through our elections and filings through the LLC workings, I would say that it is advantageous that we give them the tools that they need to provide the services that they do for Wyoming, but also as they provide services for the business acumen that we are looking to be number 1 in the nation. So I would ask for your positive aye vote on this amendment. Thank you.
Representative Campbell.
Thank you, Mr. Speaker. I rise for and with this, as I believe that this agency does have the ability to be a revenue generator. And in committee, I heard under testimony that this would get 25 to 30 revs, would be used 25 to 30 times. As such, this would pretty much bring in enough income to fund that position in question. So I am for this. Thank you.
Representative Larson.
Thank you, Mr. Chairman. I just, to point out that there's been 2 conversations with that number 2 executive, both trying to accomplish the same thing. One was the computer system. The second was, when that was turned down, was, well, if we don't get the computer system, we can do it with more people. And then that came back again in the December meetings, and I'm not sure. I'm wondering if the number 2 committee here in the House or with the joint committee revisited that in the last couple of days, and if they could report to us what action, if any, was taken then, so that we don't have this conflict between agencies on how that approach is going.
Representative Knapp.
Thank you, Mr. Chairman. On and for the amendment, you know, this particular agency has asked for both, for positions and for a computer system, has gotten neither. And yet, year after year, the filings increase. Thank goodness for the state of Wyoming, because we receive fees on those filings. They're increasing exponentially every year. This simply allows us to have the customer service, which is required. So for regular filings, they have a required amount of days that they can get those done in. And they're being overloaded with those filings. This particular instance is for special filings. When somebody's doing a merger, for instance, they need 24-hour service perhaps. And it requires one person out of that crew to move over and to handle those filings. And so the regular business goes on, which also has a deadline. So if the 3 positions are granted, I believe this one goes away, but this position itself would be paid for in a matter of weeks from the fees that we receive in filings. Thank you.
Further discussion on the amendment? Oh, Representative Yoon.
Mr. Chairman, thank you. Members, just to make it abundantly clear, I'm for the bill. The bill is good. It's good for business in Wyoming. It's good for Wyoming. It's good for Wyomingites because we're going to get that revenue coming in. The question that is upon the amendment is whether a new position is required specific to this bill. If the secretary, sorry, if the second chief elected needs more staff or needs a computer system, that is appropriate to go through appropriations. But it wasn't convincing that that position was needed for this bill. And so I'm not sure why we have this 2-horse in the race sort of deal, but I think the real appropriate measure of whether that elected needs more staff goes in that bill that we'll have coming up. I don't think it's necessary for this bill that I, again, wholeheartedly support. Thank you.
Representative Pendergraft.
Thank you, Mr. Chairman. I spoke at length with the number 2 executive. I went through an extensive tour, learned a lot about how they operate, how they have cross-trained, and how they're all working. And folks, as far as I'm concerned, you can sit here and talk till 2 o'clock in the morning. You will not change my mind. The help is needed.
Representative Singh.
Thank you, Mr. Chairman. Just to tie this all up, if we pass this amendment and we end up passing the supplemental budget, this provision goes away. Thank you.
Question having been called, all those in favor of standing committee amendment, please say aye. All those opposed, no. Standing committee amendment number 1 has been adopted. We're back on the bill. Question having been called, all those in favor of Chairman Washit.
Thank you, Mr. Chairman. So my question has to deal with the range of these fees. There's substantial range allowed in this bill for how much these fees will be. How is that determined? And if someone could explain, what is the advantage of an expedited filing when you already have the strict timelines that we have in Wyoming?
Representative Singh.
Thank you, Mr. Chairman. So the determination of the actual cost of this fee, which is up to $5,000, would be established by the good number 2 executive, as well concerning under what circumstances this would be applicable. Say there's a merger going on, and as previously mentioned, there is 24-hour access was needed. This creates that opportunity for fast, business-oriented filings to take place.
Representative Lawley.
Thank you, Mr. Chairman. To give further color on the issue of the scale and the purpose, there could be situations when you're doing large transactions, maybe you're acquiring a company, or you're going to, again, merge with another company, where you do not want, for various reasons, that to be known. You don't want to have to be out there and something filed. You could file it earlier, but it really doesn't, it could mess up the deal. And sometimes in the deal, some things shift and you don't do what you maybe planned to do at the beginning. So there are needs in those kinds of transactions for immediate filing that is, you get approval of. So then that can be announced, but you have it done. So there are reasons. It doesn't happen every day, but those types of transactions need and are willing to pay for those kinds of services. And you're seeing them more and more. And so it really does work where they need it within less than 24 hours sometimes, need that done to have the transaction completed and all the pieces put in place in a timely manner. So that's the reason for I think the range. I'm sorry, I turned myself off. There could be situations where maybe you don't need 24 hours, but you need it in 3 days. So maybe the fee would be less. And so it really is going to be gauged according to the needs of that transaction or situation. So, and that's kind of getting to be a thing, and being able to do that quickly. And there are many states that do it and operate for that way. It's kind of in a way, you could call it a concierge type service, but they will pay for it. And it does help commerce. It really will help the commerce in the state of Wyoming, and can continue to put us in a good position in that area. Thanks.
Question having been called, all those in favor of Chairman Heiner's motion that when the committee of the whole rises to report, do so with the recommendation that House Bill number 47 do pass, please say aye. Aye. All opposed, no. House Bill 47 has passed the committee of the whole. The next bill for our consideration is House Bill 46. The reading clerk will read the bill.
House Bill 46, sponsored by Representative Strzok, Homeschool Freedom Act. Mr. Speaker, your committee number 4, Education, to whom is referred House Bill 46, Homeschool Freedom Act, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Andrew, Bratton, Gugamas, Kelly, Lawley, Singh, Strzok, Williams. Noes, Representative Erickson. Representative Andrew, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Andrew.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 46 do pass, and I'll turn over the explanation to the sponsor.
She's behind you.
Who's? Oh.
Sorry.
Representative Strzok.
Obviously, I wasn't loud enough. So, thank you, Mr. Chairman and members of the House. So I'm Representative Strzok from House District 6, and I'm here to present House Bill 46, the Home Freedom Act. So I just wanted to remind you, I handed out a handout. If you guys, I don't know if anyone saw it yesterday, if you'd want to look at it again. But currently, under Wyoming law, homeschool parents are required to submit their curriculum to their local school board for approval, and this bill repeals that requirement. And this bill would give parents the right to educate their children at home without government overreach. And just for your information, 11 states have never required this kind of notification, and they have no requirements whatsoever. And so just a few of them is Idaho, Texas, Illinois, Michigan, Iowa, and Missouri. And Wyoming would be joining them. And importantly, this bill would not change the way homeschool children participate in public school sports and activities. And as Wyoming law already protects access of homeschoolers to these activities in WS 21-4-506. So thank you.
Thank you, Representative. We do have a committee of the whole amendment. Representative Jarvis.
Thank you, Chairman. I am withdrawing the committee of the whole amendment number 1 because I intend to bring a revised version back to the second read.
Thank you, Representative. Committee of the Whole amendment has been withdrawn. We're back on the bill. Discussion on the bill. Representative Larson.
Thank you, Mr. Chairman, and I'm largely in support of this bill. Have grandkids at homeschool and think that my kids do a great job with that, and I get what the bill's trying to do and like it. I think the question I've got for the bringer of the bill, the sponsor of the bill, is to it's the same thing. We think parents have a right to raise and to take care of their kids, and we ought to stay out of their way. But then we have some parents that sometimes don't do that, and we have mechanisms there, neglect. We have some other things that we look at, and so I'm curious when we look at Child Protective Services and they have in their statute under neglect for the purposes of education. We see in our public education, and we've worked with this a lot to try and rectify that, somebody that, you know, you may have a family that doesn't have their kid go to school for 30 days in a row, and you have your resource officer or whatever, they go and they try to attempt that. Is there a provision? How do we deal with that on homeschool? Because I think the curriculum thing was kind of the tie to that. Not saying that it was the right tie, but I think that was the tie. So how do you envision, or how would you address educational neglect, or is there such a thing, in your opinion, in that homeschool realm?
Representative Jarvis.
Thank you, Speaker. Chairman. I want to speak a little bit to this in my role outside of being a legislator. For those of you who know, I have been in educational administration for quite some time now and have a doctorate in educational leadership and a superintendent certification. And that being said, I have spent in central office for several years, many of my world around state reports and accountability and why things exist. And the reason that I'm bringing forth a upcoming amendment is actually to kind of help support this moving forward in the right way. Because I see the way that it's written right now, it feels good and it looks really nice. But there's this kind of what my colleague representative in a place that I used to reside, there is this Child Abuse Prevention and Treatment Act. I can't tell you why 11 states have refused to honor it, and they haven't chose to do anything with it. But it's a federal act that requires states to establish laws mandating that certain individuals, and they call out specifically teachers, doctors, and social workers, report suspected child abuse or neglect. This includes concerns about children not being properly educated or cared for. So it sticks the public schools in this funny spot because our state reports and our state requires the public schools to actually take on all children between the ages of 5 and 16, whether they are in our school or not in our school. The only exemption is if they're enrolled in a private school or a charter school, they're not our problem anymore. But what happens is we get these lovely phone calls that say, hey, there's this kid running around wild out here during school days, school hours, and then the school's required to go investigate. We have to go find that kid. The way it's written right now doesn't exempt us as public schools from actually having to locate every single homeschool student under that act. Like, we will have to go now find 500 kids versus 10. The beauty of what was there before, when we get that phone call and we know that that kid is being homeschooled, our response is, not our deal. That's a kiddo that's homeschooled, and they have every right to let their kid run and do whatever they want. As I know, the intention of this bill is to move so that homeschool have a lot more autonomy. And I heard as I popped in and out of the committee meeting, I heard a lot of my fellow educators say, great, just provide notification. Just let us know. Because if you let us know, then we can easily speak to, when we get that phone call, say, nope, that's a homeschool kid, thanks. And that is no longer the burden of the public schools. Does it really prevent that child abuse? I can assure you that most homeschool parents are not abusing their children. The homeschool students are, for the most part, we have the rare occasion where we get an 8th grader, which we did in Natrona County just not too long ago, that
Mr.
can't read.
Speaker,
So,
point of order.
sure.
What's your point?
My point is that we're not talking about child neglect, we're talking about curriculum.
Point taken. Let's focus on the bill, please. Thank you.
So, perfect, I respect that, but we kind of are, because that's the only reason that we have to go find homeschool. So we could eliminate the curriculum requirements, absolutely, but we can't get rid of this act that requires us to go find them. So, and the way it's written right now actually leaves it up to the schools to interpret how to locate these kids on what they would want to do to be able to fulfill that ensure curriculum. It doesn't make the schools exempt from being involved.
Representative Lean.
Thank you, Mr. Speaker. I hope you know that many parents know best in their child's education, and many times homeschool parents tailor that curriculum to each individual child, regardless if they have 1 or if they have 10, or maybe more. I want you to know that there can be a successful partnership with individual school districts and homeschoolers. This can happen so that students can still utilize the curriculum within the public education system that may be something like the arts or sports, and that can be achieved. This is just removing a bureaucratic layer that we don't need. There is a state and district, the states and districts could save money in the education world because every district has somebody that is compiling all of the homeschool information. Their time could be better spent on something that is in regards to the public education system. Many of my constituents have reached out and said, please support this bill. So here I am. And as a homeschool mom, I also support this bill. In all my years as a homeschool mom, I will tell you that I have never been questioned by a district as to what curriculum I am using. I have managed to maintain compliance with the law and submitted my scope and sequence and letter of intent to my district. I know that there is withdrawal papers required if you are coming out of the school system to homeschool, so that parents will be able to recognize, or the school districts will be able to recognize by address if that child that is reported as an educational neglect, it matches a student in their system, or if they are not registered with the district. That seems like a very simple solution to knowing if the child belongs in the district and they need to investigate, or if the child doesn't belong in the district and they don't need to investigate. I stand in favor of this legislation so that homeschoolers have the opportunity to do what is best for their children. Thank you.
Representative Kelly.
Thank you, Mr. Chairman. I rise in support of the bill, and ditto.
Further discussion? Ready for the question? Question having been called, all those in favor of Chairman Andrews' motion that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 46 do pass. All those in favor, please say aye. Aye. All those opposed, no. No. House Bill 46 is passed the Committee of the Whole. Next bill for our consideration is House Bill 80. The reading clerk will read the bill.
House Bill 80, sponsored by Representative Knapp. Stop ESG State Funds Fiduciary Duty Act. Mr. Speaker, your committee number 9, Minerals, Business, and Economic Development, to whom is referred House Bill 80, Stop ESG State Funds Fiduciary Duty Act, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Campbell, Heiner, Knapp, Lawley, Riggins, Schmid, Tarver, Weber. Noes, Representative Larson. Representative Heiner, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Heiner?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Bill number 80 do pass. And I further move the adoption of the Standing Committee amendment. For explanation of the bill, I turn it over to the sponsor from the good country of coal.
Representative Knapp.
Thank you, Mr. Chairman. You know, this bill is an example to our legislative body that from testimony from one of our top 5 electeds, testimony from our agencies, public opinion, and public comment that help to make a bill better. This bill, in essence, holds people that invest our retirement funds, our rainy day funds, and our funds that we set aside for the future in a responsible manner. So whether you hire insurance salesman, whether you hire a broker, whether you hire a fund manager, your expectation is that they invest those dollars prudently and don't look at any other issues besides getting you the best return possible. This bill takes that into consideration. And I'm going to explain the bill with the amendment, the Standing Committee amendment included in it, because it is so integral to the bill itself. So this bill is ESG State Funds Fiduciary Duty Act. And it's an act that basically says how we hire our fund managers, how we retain them, their responsibilities, the proxy responsibilities. And so on page 1, section 1, we talk about the investment of those funds and the consideration on only financial purposes. On page 2, we have some definitions of fiduciary and the fiduciary commitment, advertising, and participation. And now comes the amendment. We're going to start deleting a good portion of the bill. And the reason we delete this is because a bill like this should be like justice. Justice is blind. When you invest, it should be blind. We do not care about factors or social issues on the right, and we do not care about factors and social issues on the left. And it took a constituent calling me this weekend and saying, why have ideology in the bill at all? And I agree. So on page 2, we begin to strike. We delete entirely lines 21 through 23. On page 3, we strike lines 1 through 23. And on page 4, we strike lines 1 through 14. And again, that was descriptive language, and I believe that the bill should be as generic as possible when dealing with finances. On page 9, or I'm sorry, on page 4 after line 20, so if we can all get there, page 4 after line 20, we have 2 very important definitions in here on what non-pecuniary finance factors are. And what that is it means fiduciary decisions that do not provide confidence in increased returns or lower risk, and instead cause alarm or concern. Non-pecuniary responsibilities that will most likely result in lower returns and increased risk, resulting in less funding being available to the state of Wyoming in general. Next, pecuniary is described as prudently determined base fiduciary decisions based on appropriate investment horizons, consistent with the fund's objectives and investment policies while adhering to compliance with statutory and regulatory guidance. Those factors do not include financial factors or the furtherance of environmental, social, governance, political, or ideological interests. So that, in essence, is the amendment to the bill, and I believe it made the bill better. I appreciate all the testimony that occurred, and I would ask for your favorable consideration.
Thank you. We're on the standing committee amendment. Discussion on the standing committee amendment. Representative Yin.
Mr. Chairman, apologies, but I'm going to move to divide the amendment.
Okay, what is your division?
Mr. Chairman, so Division 1 would be lines 9 through 18.
9 through 18.
And Division 2 would be everything else.
The chair will rule that that is divisible.
So members, the reason that we usually insert definitions into bills is because those terms are actually used in the bill. There is no instance of the term non-pecuniary financial factor anywhere within the bill, and the definition itself doesn't actually act on anything. So by inserting an extra definition, we are just making the green books larger. It doesn't do anything. So I'd ask you to vote no on Division 1.
We're discussing Division 1. Discussion. Representative Knapp.
On and against, the two definitions are congruent with each other. One meaning non and the other pro. And it is found throughout the rest of the bill in describing financial in pecuniary manner. Those definitions actually come from another document that we use for our investments, already used since 2023. And because of that, they were included into this bill.
Further discussion on Division 1.
Mr. Chairman.
Representative Yin.
Mr. Chairman, so I've been corrected that it is used in the pecuniary financial factors definition. So my apologies. I vote aye on Division 1. Thank you, Mr. Chairman.
Thank you. Question having been called on Division 1. All those in favor of Division 1, please say aye. Aye. All those opposed, no. Division 1 has been adopted. Division 2 of Standing Committee Amendment. Question having been called on Division 2. All those in favor, please say aye. Aye. Opposed, no. Division 2 has been adopted. There's also a Committee of the Whole Amendment. Committee of the Whole Amendment number 1, Representative Larson.
Thank you, Mr. Chairman. So at this time, I'll move Committee of the Whole Amendment number 1 to House Bill 80 and ask for your favorable consideration. Members, if you turn to page 8 in your bill, what this does is delete subparagraph H and J. And in testimony in committee, we heard from many people that having penalties in for our investment managers will most likely force them to leave their contract, leave their job, because who's going to sign up for a penalty that's 3 times the amount paid to them? And well, I understand that this bill may be important in certain aspects. I think that we have really good investment managers, and we don't want to scare them off or I think,
send any messages that we're unappreciative of what they do for us, because they provide 30% of our investment income. So I ask for your aye vote on this amendment, and we'll stand for any questions.
Further discussion on Committee of the Whole Amendment number 1. Representative Knapp.
On and against the amendment. We did have testimony. So if you think about it, the fund managers, when they first looked at this bill, saw it as a potential problem because, number one, if you dial down into individual companies and they have an ESG statement, the thought was, well, you couldn't invest in anything, right? So the fiscal impact reflected that. That's not what we're talking about here. We're talking about a situation in which you have a fund that uses any issue, whether it's social or otherwise, as a large percentage of their fund. So in other words, they've gone out and looked at 90% of their fund being related to social issues rather than your return. So obviously that is a concern. The second part to that is accountability. So this bill does have accountability in it. And that accountability is if we invest our money, in other words, our employees' futures, if we invest that in a company and they should mislead or misrepresent what you have invested in, absolutely there should be a consequence to that. And I'll tell you why. Because many of those funds we invest in are long-term funds with high dollar amounts. And the reason we do that is so we have access to other funds that we may not have access to not investing that way. So if we are misled at some point by a company and we can't retrieve our funds out of there, if they're long-term without a severe penalty, absolutely we want to have something written into the contract where there is a consequence for that, so we can at least offset our losses in getting out of that fund, if for that reason alone. You'll see a further amendment that deals with our own employees. Certainly, if our own employee went rogue and invested in a way that is improper, the consequence to that may be to be fired. That may be the only consequence we need to have. So a later amendment will deal with that. But for this amendment alone, absolutely in our contracts, we do need to have some mechanism to ensure that the people that we choose to invest our money are available if something does happen and accountable if something does happen. This is like I said, this is our future. This is our employees' future. These funds are very important to our retirement, it's tens of thousands of employees. And so this just codifies what we already have in our investment policy. It ensures that our investment policy, using the language that we've pulled into the bill, is backed by law, so that if we do have a future elected official that comes along and they have different rules, we have it in law that the fiduciary responsibility is to the client to get the best return and not to involve yourself in social issues.
Representative Larson.
Thank you, Mr. Chairman. I don't know if this is for the bringer of the amendment or the bringer of the bill, but on page 8, as we're discussing the possibility of removing H and I, on page 8, line 4, where it refers to person, is that an investment funds manager that we're in contract with, or is that one of our agency's investment fund managers that is employed by the agency? Could you just clarify that for me, please?
Representative Knapp.
The way it sits now in this version of this, it would involve an employee. Like I said, there is an amendment coming that will correct that, to take a state employee out of that responsibility and just include the funds that we invest in.
Representative Lawley.
Thank you, Mr. Chairman. To the bringer of the bill, my question is, on this amendment, you were talking about this section H and J. but there were terms you were using that aren't in the bill, and that's what concerns me, is it doesn't use the word willful, intentional, things like that, and that's one of the concerns I have, is this is structured in such a way that it really is difficult to protect a person that, and zero in on that kind of activity as opposed to someone made a mistake. So again, I just want to know if you're open to some amendments to that language.
Representative Wiley.
Thank you, Mr. Chairman. You know, we're sitting here talking about this, and we're talking about this, you know, the future, and we've heard how much we're generating for the general fund every year. A third. This is a third. And we're holding our children's futures and probably our children's futures in our hand with the decisions we make today. I mean, we're writing letters to them, and I agree upon that wholeheartedly. I'm with you. But when we're doing something like this, and we talked about how it's politically motivated, and we don't want to include that, I understand. But I've had conversations with several of you over this little 3-letter word here. And so last weekend, you know, I looked up a group of companies, and there's about 500 of them, right? And it has to do pretty good with the stock market. And I was going through there, and I couldn't find one that didn't have something to do, you know, with the 3-letter word that we're talking, ESG in this bill. So if we're not careful and we put too many sidewalls up here and we keep it too vague, and we're not getting the best people to manage these funds, we're jeopardizing that future that we're talking about. A third. Every year, a third. And then the way we invest, compounding, we're going to put ourselves in a bad place really quickly. And then that letter to the future, it's not going to be so bright. We really need to think about this. This is very important.
Representative Bear.
Thank you, Mr. Chairman. There was a comment made by the good lawyer from just on the west side of the Bighorns about a couple of terms. Those terms are found in Black's commentary. They're very common, and this body, prior to many of you arriving here today, did debate the word knowingly for over 4.5 hours. I think that might be a record for one word, but I think the same is going to be true of those words. So that's just non-issue. We know what the meanings of those words are. We don't need to define every word in the statutes. But I would also say that, as the previous speaker said, this is an important issue, and we need to pay attention to what the cause and effects are. But I would point out that our executive and the attorney that represents the state has already sued the top 3 firms over this very issue. And those top 3 firms have been in the news saying that they're withdrawing from this type of ideological investment. So if we're already headed down this path, putting this into our statutes is just a prudent matter. Not to mention the fact that the executive in charge of investments for the state has used this same terminology in the methodology that they already use. So this is just putting it into statute and putting some penalty if people fail to follow the statute. Thank you on and for the bill.
Representative Larson.
Thank you again, Mr. Chairman, and I think the intent of all of us here is to try and protect our long-term investment of funds and have them be invested for pecuniary, I never can say the word, the P word, we'll call it the P word for me today, when we're investment for the highest return. We've had this conversation now for probably about 5 years, and those of us who've been serving on CapFin, the Capital Finance Committee, we've been talking about this, and there's just some little nuances here I'd like to share with you on whose responsibility is what. There, as you look at sovereign wealth funds and who should have the responsibility of investing them and who has the fiduciary responsibility and accountability for that, it's really your investment funds committee. They're selected, and there was a document that I think it was the 20 largest sovereign wealth funds entities got together and they created this paper. It's called the Santiago paper. Sounds like a movie, could be, where they kind of sat down and they talked about governing principles for sovereign wealth and how to avoid common pitfalls or stumbling in that impacts negatively the investments of a sovereign wealth fund. And one of the things that they talk about is a separation of powers here to make sure that the investment committee, which really has the power to make those decisions, remain as independent from all influence as possible. Now, and they really come back and says really needs to be separated from the pressures of government, because we do our political things, right? And it just really needs to do that. We just done that in our standing committee amendment, where on line 25 of that, whatever page that is, it talks about does not include the non-pecuniary financial factors or the furtherance of environmental, social governance, that's us, political, that's us, or ideological interest. That's why we keep it. And so why is our chief executive and that legal position that represent the state involved? Because the executive is part of the State Loans Investment Board that has a fiduciary as well, that the Investment Funds Committee, when they see a foul in how our investments are being made, can then use those resources to come back. Keeping that separation or drawing that line in the sand to keep us all a little bit aloof of how we invest for the retirement system and the Treasurer's Office is really important. Not that our intentions aren't valued and important. I think that keeping the powers that or the mechanism that currently exists to bring action if we find those investments are being done inappropriately, stay the way they currently are, to allow the Investment Funds Committee and the State Loan Investment Board to react as they have. I think that there's value in removing the language out of the bill that this amendment brings, but I think as we've looked at the House House Committee amendment that talks about government political things, I think that the good bringer of the bill indeed is trying to draw that line in the sand. And again, we're just trying to clean this bill up to where we don't have a legislative statute that then can conflict with what our investment people's investment policy is. We need to keep that line separate. So I think it's a good amendment. I think it adds to the value of the bill and would hope that we could support it.
Representative Lawley.
Thank you, Mr. Chairman. I want to respond to the comment made by the good Chairman of Appropriations from the land of the camels concerning, I'm really encouraged that you have a copy of Black's Law Dictionary. It's usually really helpful, but that really wasn't my point. My point was the good bringer was using those terms to describe when an action would be taken, but those terms do not appear in the bill. And it's very important, if we're going to wade into this area of some kind of a ability to act and enforce, we're going to have to be very careful in what we really feel is appropriate. And I don't see those words. It would be helpful for words like willful, intentional to be in here because they're not in the bill. So my issue isn't what's the definition of those. I know well the definition of them. I've argued them in court many times. The issue is they're not in this bill. And if we're going to have penalties, we need to be very clear and concise. Think of yourself in your own work situation that you've ever been in. And if there was some penalty being put on you, you would want to understand exactly at what point in time you would be violating that. You would want to understand what is the intentions that you need to have, or else you are just operating in some no man's land, always under the threat of some order from the Attorney General or action from them. So these words matter. And it's more than just whether or not they're in Black's Law Dictionary, it's whether they're in the bill for the amendment.
Representative Williams.
Thank you, Mr. Speaker. On and for the amendment, to the former speaker's point, when you consider the investment managers that we have here at the state, they are in part responsible for the amazing returns that we currently enjoy. And I feel like the bill in its present form is moving the goalposts, and as we just heard so passionately, not fair to those employees that really are responsible for our success. I'd encourage a yes vote on this amendment.
Representative Nicholas.
Thank you, Chairman. So on and in favor of the amendment, ladies and gentlemen. So on Friday, there was testimony on this bill. Testimony from the Wyoming retirement professional and testimony from the chief investment officer from the state treasurer's office. Combined, they invest roughly $40 billion of state dollars. $40 billion. The testimony on Friday was with this provision, this penalty provision, Wyoming Retirement will lose approximately $1.2 to $1.3 billion in 3 years, period. There's also testimony by the chief executive officer of the state of Wyoming that they will lose $3.8 billion in 3 years. So this provision alone, this triple negative penalties, is going to cost the state over 3 years roughly $5 billion. That's the number they testified to. So we took the amendments that were just added to the bill, and so I sent emails to both of them, and I said, okay, now that we've corrected the current amendments, does this penalty times 3 still create that same impact on page 8? And both of them responded absolutely. In fact, this is one of the key linchpins of why the current professionals, and by the way, I think we spend between $40 to $50 million a year for investment professionals in the big fund, and close to 20 to 30 billion a year for our investment managers on the retirement funds. That's what we pay for these professionals, and they are the best of the best. Right now, the state retirement is number 2 in the nation, literally, for retirement funds and the rate of return over the past 3 years. If you look at our permanent land fund by our state treasurer, it's in the top 5 quartiles in the last 2 or 3 years. You go back to about 2008 up until 4 or 5 years, 6 years ago, we were in the bottom quartile, and the same with the retirement. What we've done for the last 15 years is we've modified who runs it, what the professionals are that do it, and how they're monitored, and how they go about doing their business. The legislature has done that. And basically, we've been helping retirement and the state treasurer's office to improve their ability to maximize the rate of return. And in fact, if you look at Wyoming statute 716 and 717, this is 718 that we're modifying here. It absolutely requires by statute that all investments are invested for their highest rate of return. So it's really kind of saying the same thing that this new language that we're talking about on fiduciary or pecuniary rate of return. And frankly, that language is already in the statute. If we put it again like this, I think it's a good idea, and I like the language up to that provision. But this penalty that has on page 8, if it stays in there, we're going to lose the current folks who are investing our money. And so they have, in all honesty, said, look, if you have this penalty in there, they're not going to do business with us. They're going to leave the state of Wyoming and go work for somebody else. And then we're going to have to find new investment advisors. That $40 million a year we spend on professional investment advisors, and we're going to get a lesser product and a lesser caliber investments. That's just what's going to happen. And so what's interesting about this whole discussion friends, is that this is all a bunch of lay people, me, you, all of us. None of us are investment professionals, and yet we're debating whether or not the investment professionals that we hire are wrong or right. And so why are we doing this? Well, because this is kind of a political statement to make sure that we're getting our highest rate of return. And so we're doing that and inserting this penalty, even though our professionals that we hire, that we're paying a lot of money, say, don't do it. They got the biggest flashing red light that you can see. So I would respectfully ask that we rely on our professionals who tell us we can't have this 3 times penalty. If we do, we're going to lose some of our staff, and we're going to lose the folks that we contract with. It's just that simple. And just think about how are we qualified to make this determination anyway, other than for political reasons? There's no reason, because we don't have the background or the expertise to do it. And if you don't believe...
Point of order.
Go ahead.
What's your point?
Mr. Chairman, the Speaker is impugning members of this body and their ability to make judgment calls on investments, and I think it's out of order to make those statements about our qualifications.
So, Mr. Chairman, it's no different than if you wanted to fix a broken leg, would you go to this body and say, fix my broken leg, where you talk to a doctor, and who's the most qualified? I think who's qualified to make decisions is an important discussion to have.
Point of order.
Point.
Mr. Chairman, this body makes decisions all the time as far as laws and policy, and we do it on the basis of the knowledge that we have and that we receive from testimony from other people who may or may not be professionals. And so it is out of order to impugn this body for its ability to make those decisions.
Point received.
So let's go to the next issue, with next problem with this, this language on page 8. We are directing the Attorney General to file an action against the various investment houses that are investing our money. So that takes us back to the fundamental first question is, well, does the Attorney General have the qualified expertise to know if those investment advisors are somehow violating the obligation to invest for the highest rate of return? The language that is just added in the new amendment comes from the brand new rule that was adopted by SLIB about 2 or 3 months ago, because the SLIB board was having the same discussion, and that is, how do we ensure that we get the highest rate of return and we're not influenced by those outside social influences? And that's how that language that between that definition evolved in the SLIB board. But in addition to that, SLIB has their own rules and regulations on requiring the highest rate of return. So we have statutes that require it, we have the SLIB board rules that require it, and now we're going to have another statute that requires it on top of it. But I would respectfully suggest that the Attorney General is probably not the right entity to bring an action. It ought to be brought on behalf of the SLIB board. The SLIB board can have an attorney to do it, because they're the entities that are responsible for the oversight of the investment of our dollars. The Attorney General is not, and frankly, he's not qualified to do it. He'd have to go out and get expert attorneys to do it anyway. So on and in favor of the amendment, and going back to the fundamental problem is, it's our investment advisors' extraneous belief, including, by the way, the professionals on the IFC, the Investment Funds Committee, because they testified on this in front of SLIB, and they testified it, the vice chairman testified in front of it on Friday, said that having the penalties is going to lose the highest quality investment services, and it's going to lose money for the state. And their estimate, and they think this estimate is conservative, $5 billion in 3 years. And then if you compound that over 10 years, that's $15 to $20 billion. So on in favor of the amendment.
Representative Larson.
Thank you, Mr. Chairman. And I'd just like to add one more thought that I haven't heard thrown out there yet. And, this amendment is dealing with the penalties for investment managers, but our investment officer, the chief investment officer of the state, already puts the language that we are putting into this bill into contracts with these investment managers. They have to abide by the language in the contract. If they don't do that, then they have breach of contract. And there's a legal course for breach of contract. So I just don't see the need for this language on page 8. And I encourage you to vote aye on the amendment.
Representative Knapp.
Thank you, Mr. Chairman. Well, we've heard a lot of things, and I want to bring us back, because I'm a layman, I'll bring us back to layman terms, especially for the new members. We have investments. Those investments are for the future of our employees. So we're all concerned with the investments and getting the best return. But what we've heard today is, well, we can't hold fund managers accountable because we'll lose all our fund managers. And yet we hear, well, we have contracts with those fund managers that have stipulations in place in case something happens, we can sue them. Well, we're in suits right now. As a good representative said, we're in suits with the top 3 investment managers in the nation, both for allegations of price fixing in coal and misrepresenting funds. Typically, in ESG funds, you pay a higher administrative cost and you get lower returns. That is why there are laws, both federally and in the state, that require a fiduciary responsibility for our investment managers to take politics out of it, to take social issues out of it, to simply invest on fundamentals that give us the best rate of return. Now, a lot of talk has been made about the IFC and the investment policy statements and our SLIB board. This language in this bill came from those policies verbatim. All I'm trying to do is codify what those investment managers follow today. And by the way, it wasn't just approved recently. It was August 3rd, 2023 is where this language came from. So for those that have said the sky is falling, we're going to lose billions of dollars. Well, let's look back to October 3rd, 2023 to today, and what is our rate of returns? Have they fallen? No, they've not. So I contend with the body that all we're trying to do is codify what is important to fiduciary duty, and that is to take politics out of it, to take social aspects out of it, to get the best rate of returns. And it is important to hold those fund managers whom we're suing right now liable in contracts to be able to recoup some of our long-term funds, which we, in our investment policies managers' words, we can't get out of. We pulled back $125 million of short-term investments with those companies in a panic. However, we can't get rid of the 5-year, 10-year, 20-year obligations that we're in because of the impact in penalties that we would receive in doing so. Yes, that should be written in a contract. Yes, we should hold people accountable. Our own employees will be taken out of this in that next amendment, which I've co-sponsored. That next amendment will come up and say, and I know we're speaking on this amendment, but there's been plenty of discussion on employees. I want to retain the best employees possible in our finances. I don't want to lose anyone. And so that amendment will help to relieve that obligation from our employees and put it on our fund managers. So I want to remind the body, it's easy to throw numbers out there. It's easy to say, boy, I wish I had some of these people as my accountant, because I could say, project my earnings. Project my earnings in 5 years, 10 years, if I do this, this, or this. They don't know. I can tell you right now, I can go online and ask, what are the top 500 non-ESG funds in the nation? And it'll list them. I can ask, what are the top ESG funds in the nation? It'll list them. It's not that hard. And contracts are being written every day with accountability in them. We have $30 billion to invest. I guarantee those fund managers want that money, and I would like them to invest it in an up-and-up way with accountability. And that is what this is about, and holding people accountable is important in defeating this amendment.
Representative Wasserberger.
Thank you, Chairman. So one of the really exciting things about this, ladies and gentlemen, is the way they do these measurements on the ESG scores of companies is it's between a measurement of 1 and 100. But what's really interesting about this is it really has nothing to do with the performance on the rate of return of an investment. The reason why I can say that is if you look at the biggest electric car manufacturing here in the country, and you look at their rate of returns, it's significantly greater than our biggest oil company here in the country. Our biggest oil company here in the country has a higher ESG score than our biggest electric car manufacturing company. That electric car manufacturing company has an ESG score of 1. Oh, careful. The company that is the big oil company has, I believe, an ESG score of about 40. And if you look at the rate of return on the electric car manufacturing company, has a much more significant return than what you have on the oil company. So the ESG score has absolutely no application to the performance of your investment. This amendment absolutely makes no sense to the bill. I'm asking you to vote no on it. Thank you.
Representative Larson.
Thank you, Mr. Chairman. And this is a great conversation, and there's a lot of intertwining with who these investments go. And I just, as we listen to the sponsor of the bill talk, I know that he's going to come in and take care. He has an amendment to come and take care of the employee component of it. When we're talking managers, it's important for us to understand that we have two kinds of managers. Ones that we send out that are contracts that live in another part of the country that then provide funds, investment funds, and oversight and manage those funds. We started moving in I think 15 and 16 to increase our internal investments to where we didn't have to use so many out-of-pocket fund managers. So when we refer to fund managers, we also have our internal fund managers, who, by the way, are the state employees, and who, by the way, this penalty thing causes us the most concern about. It's sue these internal ones, sue the external ones, but the internal fund managers and the concerns that we're hearing from the two big entities that invest for us are worried about their internal fund managers that they've worked hard to put together leaving because they feel that they're going to be penalized for that. Now, if we have some amendments to take care of that, that's fine, and hopefully so. But that's, when we're talking in fund managers, there's two flavors there, external and internal, and they're all worried, and the internal ones are worried about these penalties.
Representative Wiley.
Mr. Chairman, I want to talk about two things and just touch base a little bit. I'm trying to resist and not talk so much, but this is a very important issue. One, we talked about how we live in a capitalistic society. That's great. It sounds like our executive branch has went through the legal system and that the markets are going to correct on their own. So I would say, to that effect, maybe it's better for us to step out of it a little bit and government not being meddling in the way that we do these things. Another thing is that I want to talk about, we're talking about how this is not politicizing something. Well, ladies and gentlemen, this is a wholly political bill, right? And we all have hundreds of folks in our districts that count on us for those reserves and those retirements and those schools that I do not want to jeopardize those opportunities and that quality of life for my folks. over a political bill. So I urge you to really question this. I'm in support of this amendment. Think about the folks at home. Think about their future. Think about that letter that we're writing to those folks. Thank you.
Representative Knapp.
Just one more comment in reference to the last speaker. The language from this bill comes out of our already existing fiduciary response. So if it's political, we're calling the number 3 executive political. If it's political, we're calling our current investment group political. This language is generic. This language is neither left nor right, just saying, please invest our funds without any issue to the side. So I would say, because this already exists and all we're doing is codifying it into law, it's not a political bill. And neither do I see our current managers as political or our executive elected into that position political.
Representative Geringer.
Mr. Chairman, thank you. And to the bringer of the bill, I would ask you, is the language that is the subject of this amendment something that also came from our top investment executive, the penalties? And if so, was it intended to also apply to our employees or his employees?
Representative Lawley.
In reference to the last speaker, this is not language that came from our person in our state who's in charge of managing our investments. This was part of the original bill. And that's why, again, I feel like we need to look at it carefully. It needs to have a definition about what it means to violate. What does that look like? I mean, I just feel like nobody would want to operate under something this broad, but be subject to control and penalty. I even think, honestly, we're talking about obviously a civil contract, but it doesn't really have a lot of due process in it. It doesn't have a lot of definition and fairness in it. So those are my concerns, and this was not part of what, from our testimony, of what the current person who handles our money in the state is operating under.
Representative Nicholas.
Thank you, Mr. Chairman. So, and I'll just regurgitate that the answer is no. There is no provision in law in Wyoming or in rule that says there's a 3 times X penalty having anything to do with this. And I want to make it clear that we're only talking about that provision. The language that the good bringer of this bill just discussed, that is in the SLIB's investment policy. And that's good language. I'm a SLIB's liaison. I was there when that language was drawn up. It took them about 3 meetings to come up with it because of the different verbiage the different of our 5 electeds wanted to put in there. But that's the one that they all agreed on at the end to use as part of their investment policy. And you know, the SLIB, they manage basically and have rules on how the state treasurer invests his money. And they have that power because we gave it to them on the statute. And there's about 6 different places in the statute, depending on which fund you talk about, that all say that this money has to be used for the highest rate of return under the investment criteria for each of those different funds. Their funds, they're managed differently because they have a different purpose. And so some of them go for a higher rate of return. Some of them are structured to have a more cash flow. Because we have our 5% spending policy and things like that. So all we're talking about is the penalty clause now, page 8. And our 2 chief investment officers, as well as the folks that they work with, those investment companies, have informed us and have informed the CapFin committee that by having this 3 penalty clause, it doesn't exist anyplace else. I mean, that's what I'm told. This is kind of a unique albatross in the process. These investment fund managers are not going to sign a new contract that says they're going to be subject to 3X penalties because they don't have to. You know, I think the Big of Rocks investment team in California, they have $560 trillion under investment. They don't need 1 billion or 2 billion from the state of Wyoming. And so there's not a high-end finance minister who's going to say, I'm going to sign a contract that is going to make me personally liable for 3 times X the penalties. That's why they say, because so all those contracts are going to go away. That's why they say, if you adopt this 3X policy, penalty policy, we're going to lose the best performing managers. The state retirement fund, $11 billion that pays out to what, 38,000 state employees, they testified Friday that if this 3X goes into place, they're going to lose $1.2 billion in the course of 3 years. It was about 160 million, then 240 million, and then 520 million, all added up. And that's the testimony. Go back and look at the testimony. That's what he testified to, and he distributed those numbers. And then the chief investment officer of the state of Wyoming got online and said, well, take that 11 million and look at our 30 billion that we have in our investment and just do the math. We're going to lose $3.5 to $4 billion in 3 years because, and both of them said that could very easily be a conservative number. So then why put in this clause? It's a penalty that is going to extricate us from these large and best producing funds in the world. It's just that simple. So on and against.
Chairman Knapp, bring us home.
Thank you, Mr. Chairman. Well, good debate, very good debate. And I would say that I'm a member of the Capital Finance Committee as well. And I didn't do this in a vacuum. You can go online today and find, just type in, are there penalties in contracts with major mutual funds from finance managers? It'll pull them up for you. There are contracts being written today with penalties in them. Because keep in mind, the penalty is something that says, please don't do something illegal. Please don't do something illegal with our funds. And if you do, here's the penalty. Now, fund managers that aren't willing to sign that, or major funds that aren't willing to sign that, I can understand why. They're in litigation across the nation with countless retirement funds today. That is why this penalty portion exists. Now, again, we'll have an amendment that takes out our employees. We certainly don't want to jeopardize losing our fund managers internally. But when it comes to holding other firms accountable that we invest our money in, and keep in mind, there are thousands, tens of thousands of investments across the nation. You could have invested in gold and earned 50%. So it's important to know that for 8 or 9%, what we jeopardize in going with a contract that doesn't have any recourse if that fund were to mismanage our funds. We can't get out of them without paying a large penalty. Should we not invest because that's a risk to us to pay a huge penalty to get out of a fund that turns out is mismanaged? It's up to the body, but good debate. I think a penalty is accountable for the people that manage our funds. Internally for employees, I think that's too much to bear for an employee to take on at the state. So I think we get rid of that. But with that, vote no on the amendment.
Okay, Representative Nicholas.
I just want to clear up a couple things. If we had invested in gold, we'd have lost money. We've had testimony for 8 years in a row. Is gold a good investment in bullion? The answer is absolutely not. So that's, I mean, we've had bills on this floor year after year. We want to invest 5% of our things in gold. It's the wrong investment. So we've got to be educated on this, folks. But our investment teams, take the state retirement, all they do is manage managers, right? Anytime any of their managers begin to decline, they get rid of them. And just like that. And they do it on a regular basis. It's a little bit more difficult to get rid of managers on the treasurer's office, but they are routinely and regularly reviewing every single manager's performance. That's what they do for a living. And if there is anyone that is mismanaging or declining to have the highest rate of returns, they get rid of them any way they can and as fast as they can. It's not always easy, depending on the type of investment, but they do. And if you sit in those meetings, you hear them talk about it on a regular basis. So you've got to make these decisions based upon all of the facts and not something that is just an attempt, to correct a couple lawsuits that are going on. And by the way, look at those lawsuits if you want to learn a little more about them. The antitrust one in Texas, it's not about. It's about coal. The argument is the reason that there's less coal being mined is because people were selling short the coal mines stocks. Well, all those coal mines have ESG policies, by the way, but that has nothing to do with the investments of our committee, or of our state treasurer, or the state retirement board. So that has nothing to do with this argument. It's a red herring on it. And it's called the Rock That Is Black. It's a firm that's in California, one of the most well-producing funds in the world. They just got out of an ESG related, it's called a 100 club of some sort, and they got out of it because of complaints like this. And that's a good thing. But on the other hand, being in that club did not impact all our investments in that company, because that is part of our highest rate of returns over the last 6 years. It's been a winner. So to say that all these lawsuits are somehow impacting our investment policies is simply not true. They're using a bunch of lawsuits to suggest, but we're number 2 in 1 or 2 in the nation on both of our funds. Let's keep them doing what they're doing. Thank goodness we've got them, because they're saving us bundles and bundles of money. So on and against, or in favor of the amendment.
Representative Thayer.
Thank you, Mr. Chairman. The representative from this fair city that we're in has continually talked about our retirement investments are in the 1 or 2 top of the nation. Do we realize that 1/3 of the workforce in the state of Wyoming are state employees? I just want everybody to think about that. And those numbers are from 2020. I'm from a district that has many state employees. We have a place that keeps people in a building that we don't want out running around in our streets, and I can go on. I am on and for this amendment.
I'll entertain the question. All those in favor of Committee of the Whole Amendment number 1, please say aye. Aye. All those opposed, no. No. Division having been called, all those in favor, please stand. Pardon? Up. No, down. All those opposed, please stand. Committee of the Whole Amendment number 1 has failed. On a vote of 33 to 25? 5. We are now on Committee of the Whole, Amendment Number 2. Representative Storr.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 2 to House Bill 80 and ask for your favorable consideration. While I remain concerned about how this bill could impact our ability to hire our external managers, it's clearly a problem for our internal managers, for our chief investment officers, for retirement system, and in the treasurer's office, for our senior, our senior investment officers and our investment analysts. They all fall under the definition of fiduciary that's referred to in the bill. And with the permission of the bringer of the bill, I brought this amendment so as to clarify that this penalty would not apply to our employees. We've done a great job over the last decade recruiting some fantastic people. It's why we're doing so well. Given the direction that this body is going when it comes to generating revenues for the state, I do think we need to make sure that we continue to hire the best and the brightest. And so with that, I'll ask for an aye vote. Thank you.
Representative Knapp.
Mr. Chairman, thank you. I just would like to speak in favor of this amendment as well. I view it as a friendly amendment, and it does protect our state employees and our ability to both hire and retain quality employees for our financial duties. Thank you.
Question having been called, all those in favor of Committee of the Whole Amendment Number 2, please say aye. Aye. All those opposed, no. Committee of the Whole Amendment Number 2 has passed Committee of the Whole. We're back to the bill. Discussion on the bill. Representative Harshman.
Thank you, Mr. Chairman. Members, I just sent you an email. It's at the top of your email box before I got up here, but it's just got two attachments. One's a little report, the top 12 energy operators in the state, and you can go on the links to their ESG statements. I think almost 90% of publicly traded companies have ESG statements. The other part, I guess I'd like you to look at this bill is a fiscal note. And you can see that the state officer in charge of our investments did not, and as well as the retirement system said that it will result in decreasing revenues. The state the state officer in charge of our investments did not submit a number, but the other group did. And you can see, and that's where you've heard this number of $1.2 billion loss and an $11 billion retirement fund over the next 3 years. And that retirement fund's been with us nearly a century. 30,000 retirees, 70,000 people paying into it, all your policemen, firefighters, et cetera, throughout the state, and on and on and on, from hospital workers to others. So that's that one part, $11 billion in that retirement system. And then we have, if you go on the Treasurer's website and you look at the monthly report, I think that November's most recent report, about $31 billion. So we're talking about $42 billion that this bill affects. And so then I asked myself, the word accountability was brought up, and I'm just wondering, what is the purpose of this bill? I mean, most bills come as a result to try to solve a problem, and I'm just wondering, what problem are we trying to solve? Because I'm serious about it. And so how could we risk, you heard, $5 billion over the next 3 years for this problem? Here's how the process would work on Committee of the Whole. If this bill does not survive a voice vote, the chairman will stand, it says it does not, did not pass the voice vote, a standing division is automatic. And then we'll all stand if it didn't pass. And then they'll count that. Having failed a standing division vote, a roll call vote is necessary, and the chief clerk then will call the roll. And if this bill fails on Committee of the Whole, is indefinitely postponed. I think it's sent a very positive, important message to our people, our state, all the people that we invest in, that this bill does not move forward today, and that we talk about it for 2 more days. I don't say that very often. You try to improve bills through the process. I'm not sure why this is here. And so I'd urge your no vote, I think, to put this away. And then finally, I guess, I don't know, Mr. Chairman, I just think finally that there's so much good news with what we've done with our permanent funds. Again, some of them longer, since statehood. We recently passed the largest state in the union up north, by Canada, as the most investment returns per capita in the United States. One of the top sovereign wealth funds in the country, 30% of our revenue. Incredible. Tremendous gift from our forefathers and our mineral companies. Incredible. This is about Wyoming's future. And so I urge your no vote on this bill. Thank you, Mr. Chairman.
Representative Campbell.
Thank you, Mr. Chairman. I'm going to curse my colleague from the same county. I think he just took all my notes. So wanted to, yes, take this away maybe from the ESG discussion. My first question would be, what problem does this solve? Because neither our holder of revenues and investments or our retirement managers take any ESG activity into account. They don't do it right now. So what is the problem we are trying to solve? The biggest impact for me, though, as representatives of our communities and our districts and the folks that live in them, is the fiscal note. And I'm going to call even more attention to it. The pension fund, $193 million hit in 2026, $387 million in 2027, $580 million in 2028. Why do those numbers matter? Every firefighter in your community, every peace officer in your community, every teacher in your community, every trooper keeping our highways safe. Every single one of those individuals is going to take a hit in their pension. And that's the gratitude we're going to give them for their service? No, that's not okay. We have to do right by them. We need to do right by them and honor their service. And the way to do that is to get out of the way and let our investment officers do what they do best. And this bill does not accomplish that end. Thank you, Mr. Chair.
Chairman Washit.
Thank you, Mr. Chairman. Members, I'd love to vote for this bill, but my mailbox is blowing up with emails. As a retired public employee, other retirees around the state feel like they have a kindred spirit in my chair, so I get a lot of these emails. And what they're telling me is they saw the news the other night after our elected testified before this committee about this bill, or they've read the fiscal note attached to this bill, and they're scared because their ability to get a cost of living increase is tied to the eventual date when those pension funds reach a point where they're 100% actuarially sound. And so if the fund takes hits, that puts off the date when they might eventually get a cost of living increase. So they're scared, and they said, Art, can you do something? So here I am. This is not my strong suit. There's a reason I don't serve on that committee, right? But I sat back and I said, if I saw this fiscal note attached to some other bill, right? I'm taking a look at a bill to deal with X, Y, and Z, and it comes with a fiscal note identical to this one. Am I going to vote for X, Y, and Z? Or does that fiscal note alone by itself give me sufficient cause? But I know how popular it is in our state to strike out at these ESG type things. I get that. I really do. But I also heard testimony that said that most of this language that we're trying to codify in this statute already exists in the contracts that the executive branch utilizes. So I'm wondering, why do we do this with the potential risk that's reflected in that fiscal note when it sounds like the executive branch has it covered? So if I don't get answers to all those things, I'm going to vote no on this bill, even though I know that it's popular. And if all you read is the title of the bill, you think that anybody that votes no on this is a real louse. But it's the details that matter. They really do, especially in something like this. So help me understand why this is a good bill, because I don't see it now.
Representative Connolly.
Thank you, Mr. Chairman. First of all, I want to say I appreciate all the work that folks have done on this bill. It means a lot to them, and it means something to me as well. ESG. How long have we heard that term? It's a relatively new term. This just started coming around a few years ago. And our investment folks have been doing a really good job. And I wonder how long ESG is still going to be around. It's almost like it's a fad thing, like DEI, ESG. These three initials all the time are just crazy. And I understand why ESG is not a good thing. I really do. But I'm getting a lot of information back from a lot of my constituents that, as one of the other speakers mentioned, they're really scared and concerned about their retirement. And I guess and so am I. I think that's something we need to consider. And I guess, do we go with our investments with something that may not always be a problem and put this into actual law? Or do we kind of sit back here a little bit and see what happens? Not all companies are doing the ESG thing. So I'm having a real hard time trying to decide whether to vote for this bill or not, because my people are scared about it. A lot of people are for it too, but I don't think they realize exactly what it's going to do to the investment. So appreciate the time.
Representative Byron.
Thank you, Mr. Chairman. In another one of my lives, I wear a volunteer firefighting hat. 10 years of it, hopefully 10 or 20 more. When my pager goes off, I go to a car in the river, house on fire, your grandmother or grandfather that might have gotten an offender bender. At the end of that, I'm entitled to a little bit of retirement. A couple $100 a month if I make it 10 more years, maybe 150, 250 if I make it 20 more years. A yes vote for this bill will take that away. We're not talking about $10,000. We're not talking about 100. We're not talking about a million. We're not talking about 500 million. We are talking about, by the time I retire, if you vote for this bill and proceed, it will be over $1 billion in just one classification of first responders. We're not talking about law enforcement here. We're not talking about search and rescue folks that come pluck some of us off a mountain, not myself, but we really need to get at the root of this and let that chief executive who is in that position, elected to that position, handle this, and let the experts be experts, trust our electeds, and stay out of it.
Representative Wiley.
Thank you, Mr. Chairman. Good cohorts of this body. I implore you, just let's take a minute and let's rise above the crazy of this world together. We're sitting here, we're debating, we're arguing, we're leg wrestling over something that is going to affect everyone in the state. We have the opportunity to do that. You know, I don't want my proctologist doing my dentistry, and I don't think any of us on this floor want that either. It's going to leave a heck of a bad taste in our mouth. and I'm not taking that home. On and against, this is really bad. This is really bad.
Representative Ottman.
Thank you, Mr. Speaker. And to go along with the, or not to go along, but just to comment on the last speaker, that created a picture I don't even want to see. Yeah, yeah. So anyway, to address this, about 5 years ago, I remember when the treasurer was putting together, or the top, they were putting together this investment team and how they searched and searched and searched for a group that would do the very best for Wyoming. And I believe that over the years, they've worked very, very very diligently to do that. And I know that one of the fellows was even brought in out of retirement, international investor, and things have gone well. We have a lot in there. But what I would say is that what we're talking about with this bill, number one, is the AG may do that. And secondly, we're talking about ESG. We're talking about not just financial, but as so many people have pointed out, political. We're a legislature. What we do is legislate law, okay? And it goes along with the ways that we believe laws should be. So let me just say, there's other states, let me see, that have passed, I don't know if can I say other states' names? No, okay. There is a state that passed an ESG bill, passed a law requiring investment decisions to be based solely on financial factors. ESG bill, ESG bill, ESG bill, ESG bill, ESG bill, ESG bill. One of the sweeping ESG bans and another ESG bill. So other states are seeing, we do not want to be at the whim of social situations. We have seen through our land grant university, we have seen that ESG has come in and governing, and we're straightening that up. We have seen that with the 3 top investment companies in probably the world, that a lot of this has come to fruition and they're being sued. If the majority of our investments are in with them, how safe and how wonderful is that? How safe is that? If that's going to be according to those types of things, and we are going back to financial fiduciary responsibilities with those issues, not companies that are trying to do NACs and things like that. So this bill is just to clean that up, that's all, and say, get back to the basics, let them. And I would just ask another thing. Since when do employees of the state tell us what they will do and won't do for us? These financial investment teams, they're getting paid a lot of money. So that's why they're here, to make money. That's why they came here, was to make money. So if they want to go somewhere else, other states are doing the same thing. So it's not like it's going to be that top. So I would ask for an aye vote on this. We need to look at this, and we need to stand up for what's right, and the direction that we're going back to is to be a productive, business-oriented, fiscally responsible state. Thank you.
Representative Lawley.
Thank you so much, Mr. Chairman. I want to respond first to the last speaker. A couple of things. I know the amendment was a little confusing, and you may not have picked up on that the amendment changed the word may to shall on page 8. So that makes a difference in terms of the interpretation of paragraph 8 on page 8. So that was part of the amendment by the standing committee. Also, I want to respond to what other states have done. Across the board on ESG litigation, there is a lot of differences because the devil is in the details. Many states put certain things down to rulemaking. It's not the statement about we don't really want those sort of things in our investment policy, and we've done that. In fact, I applaud the bringer of the bill because he worked very hard on the issues that related specifically to investment policy. The thing we ran out of time to get done was the issue on page 8 of the penalties. And they are not reflective of any of the comments that were made by the public, but we closed public comment, and this may ring a bell because I brought it up in the rules discussion yesterday, that this is the very thing. I've tried to table it to another day to reopen the testimony so we could go back to this part of the penalty. I think the bringer of the bill's intention was to align it and to do it well, but I don't know why we're rushing. We ran out of time, and this part of the penalty is not well done and has a lot of issues with it. It is not a part of what you see in contracts that has been sort of suggested. This is not reflective of what the contracts actually require. Let's codify that if you want, but this is something entirely different, and it tries to create almost like a new cause of action, but without specific what it actually means to violate it. Nobody would work under those conditions. If you really understood the law, you wouldn't. So this is very concerning. I had hoped we could open up the testimony and come back to this particular provision on page 8. I know we're past that amendment. I understand, Mr. Speaker, Mr. Chairman, but this is why I can't vote for this bill. I too, like the good chairman of Judiciary, have received so much email and calls from people in my community. We haven't even mentioned teachers yet that are part of the Wyoming retirement system, that are very concerned about the decisions we're going to make. And we know from the testimony we did receive that this provision was problematic. It was no doubt. There was literally no one that suggested it wasn't. And we just didn't get to work on it. So again, I'm going to have to vote no. I don't want to vote no. I support the idea. I really, really appreciate the work the bringer brought and made it a better bill, more clear, more speaking in terms of financial language. I told the bringer when he told me about the amendments he was going to bring, I was so thankful because I had before me what our chief investment officer has as policy on one side, and on the other side I had the bill, and they were written in two different languages. One was in the language of finance and investment that makes sense and is specific so that one can understand what you're actually saying in that realm. The other was written in the language of politics. It was written in the language of broad statements, and we got that all out. And the good bringer did a really great job of getting that out of there. But we didn't get to this portion. Page 8 did not get looked at and revised according to some of the testimony from our investment advisor. So this is where, for me, the big hangup is. And why I really supported the amendment to take it out, at least for now, until we could work on it. But I can't vote for it in the form it's in. Knowing what I know and knowing how it's going to affect our ability to get people to work with us on our investments. I wished it was different. I wanted to vote for this bill. I worked hard. I think the good bringer of the bill worked hard, but we didn't quite make the goal line on it. And that matters. This is not a small matter. It's not a small matter at all. And to all the people at home that depend on the state retirement system, we owe them to get it right. I don't understand why we are rushing this across an imaginary goal line. I really urge you to vote no on this bill. Thank you.
Representative Williams.
Thank you, Mr. Chairman. I like House Bill 80. It sounds good and makes me feel good. But it does seem a little rushed, like we just heard, and it's more than a little unclear. And I'm just not persuaded that it's not going to hurt real people in my district, like we just heard about. And when I consider the folks back home who have funds invested with the state and depend on those funds for their retirement, I also don't feel like I can support this bill in its present form. In the last day or so, they've made it abundantly clear that the legislature is, in their view, not authorized to play politics with their retirement funds. Thank you.
Representative Lucas.
Thank you, Mr. Chairman. I understand that I am a new legislator, but in my adult life, I was a banker for over 40 years, and I'm quite familiar with investments in that world. And when I read the fiscal notes, I'm not reading much. I see nothing there that other than some numbers thrown on paper and nothing to back it up. And I haven't heard anything to back it up that is real numbers. And I'm a numbers person. So I feel like to make a decision based on this little bit of information is kind of rushing scared. And I'd like to see this go a little further so we can get some more information and make a better informed vote. On and for.
Representative Yin.
Mr. Chairman, thank you. Members, I'm curious on whether this body believes in the free market. So if we do believe in the free market and don't believe in government meddling into the market, why would we tie our hands in investing in the market? We heard about other states that say, they can only invest in ESG funds. That's also terrible. You're saying for a political purpose, we're going to restrict how much money we can make in the free market. That's exactly what this bill does. It just does it in the other opposite direction. Why wouldn't we allow our investment fund managers to invest in all companies and have them determine what makes the most money for us? That is their job. We would fire them if they didn't make the most money for us, right? They literally wouldn't be employed by us if they didn't make the most money for us. So what's the purpose of tying their hands except for them to tell them that you have to do what we say, otherwise don't work here anymore? And if we don't want the best people to work here, we don't want the best people that can make us the most money for Wyoming, then we're saying, you know what, for this political reason, I want to make less money in the market, and that means to pay for all the services that I need in the state of Wyoming, I need to tax other people instead. So if we're saying we want to make less money, go at it, make that vote, say we want to make less money. Just realize what the consequences to that will be for saying you're making a political message, just the way some other states are making political messages, but they're also doing the same thing. They're harming their bottom line, which is making the best return for the state of Wyoming. And if we want to protect our fiduciary obligations, it doesn't make sense to pass this bill. Thank you, Mr. Speaker, Mr. Chairman.
Representative Schmidt.
Thank you, Mr. Chairman. There's a lot of fear being spread around in this chamber. I believe it's unnecessary, and I say that from personal experience. I personally ended a 20-plus year banking relationship over ESG. I pulled all of our accounts, I pulled all of our investment accounts, and I moved them because this bank, after 20-plus years of dealing with my company and the growth of my company, decided that they could no longer loan me any money to buy another workover rig to service my oil and gas customers. So we pulled everything, and we moved it to an institution that believes in oil and gas and believes in one of the traditional industries that built this state. There's no fear in this moving these or not investing in ESG companies. When I move that money that we had invested is doing as good or better than it ever did before. There's a lot of options out there, and I'll tell you, I don't have near the money that we've got in this, that this state holds. They're going to pay a lot more attention to us than they do me. They're going to do their best, and they can find companies to invest in that don't kill our traditional industries like oil and gas and mining and agriculture. The real fear here is to continue to invest in these companies as they turn around and use those dollars to kill our traditional industries and deliver them a slow death. And that's what's happening. And if that continues to happen, we're not going to have to worry about firefighters and troopers and county employees. We're not going to have to worry about them because we're not going to have any traditional industries left to fall back on. I urge you to vote yes on this bill. It's a good bill and it's time. It needs to be done. Thank you.
Further discussion. Representative Knapp.
Okay, I'd like to wrap this up for everybody. This is the first reading, so we're not rushing. We can come with other amendments if we want to. But I would say this, there has been a lot of talk, and I have constituents too. And you know what? I care for the people of Wyoming too. And the true fiscal note would be to go back to October or August 3rd, 2023, because that's when this language, that's when this, in essence, bill became policy for not only the top executive to invest your funds, but for the investment policy statement and for the SLIB board. So have we lost money since August 2023? The fiscal note on this is very peculiar because it projects into the future as if we didn't invest in anything. We didn't invest in anything because the testimony actually was there's not a company out there that doesn't have an ESG policy in some way, shape, or form. So as somebody mentioned earlier, it's on a rating scale. And all we're saying is whether it's issues to the right or to the left, social issues, environmental issues, keep it out of your decisions to invest. If you have a portfolio that is 99% save the puppies, it's a concern because you're going for a cause versus a return. So in ending this, I would say to all the people watching at home, to all those people that we've scared to death, that somehow their retirement is gone, that their retirement is no longer going to be invested in, I would say to them, we've been doing this policy now for a long time. And the policy is keep all that stuff out of investing. Invest on the percentage that we get back for our retirees and for their retirement. And that's it. If you were to vote no on this bill, you're voting against the top official in charge of our money. You're voting against the ISP document. You're voting against the SLIB policy. All we're doing is codifying that into law so that if another person came along and had the intention of doing something else, this is what we have to fall back on when we create policy, when we create rules. And so keep that in mind when you're keeping in mind the people at home. Don't scare them to death. Don't tell them that we'd never have another investment ever again. Maybe if you want to do a deep dive, go back to August 3rd, 2023 to today and see if our investments crashed, because they haven't. Thank you.
Good debate, members. Oh, Representative Nicholas.
Ladies and gentlemen, if you look at your emails, I think I only sent it to the Republicans because that's all I didn't know how to quite send it to everybody. I send out an email that it comes from the Chief Investment Officer for the retirement that talks about what he believes the problem is with this bill. And that is page 8, line 2. And that's the penalty of times 3. We're not talking about the language of August 23rd, 2003 that SLIB adopted. That is good language. So that's not the issue. In fact, that language is not new either. If you look at Wyoming Statute 915-103A, if you look at Statute 9-4-1203B, if you look at 9-2-2304B, if you look at 9-4-715Q, and 9-4-716F, every one of those statutes, and this coming from the floor of this House, and a lot of those, when I was chair of the CAPFIN, and when the good person for the Sentinel State was the Speaker of the House, establishes for all of our funds that the highest rate of return is required. And the contracts that our good folks at Wyoming Retirement sign with those investment managers and State Treasurer's Office managers all have, you will achieve the highest rate of return. without any other consideration, period. That's what the statutes say. That's what said that we did in the SLIB in August 28, 2023. And that's the problem with this bill, is it doesn't do that. It interferes with that by saying there's a penalty, so we can't get the best investors to do the work and get the money and get the highest rate of return. So it's really two different things. So really, that's the only problem with this bill. Everything else is fine. But because it's in there and we won't remove it, this bill has to die. So on and against.
Representative Knapp.
Mr. Chairman, got to have the last word. If there's a pause in the penalty portion of this, bring an amendment. Bring an amendment in second reading or third reading that somehow puts into contracts some accountability, but maybe doesn't necessarily spell that accountability out. So that it could be in our contracts. Let's get this moving forward. Let's get our policy codified, and let's do good for the people of Wyoming. Thank you.
Question having been called, all those in favor of Chairman Heiner's motion that when the committee of the whole rises to report, do so with the recommendation that House Bill 80 do pass. All those in favor, please say aye. Aye. All those opposed, no. No. House Bill 80 has passed the committee of the whole. Division having been called, all those in favor, please stand. All those opposed, please stand. Representative Gehringer, are you in? House Bill 80 has passed committee of the whole on a vote of 34 to 26. Next bill for our consideration is House Bill 18. Reading clerk will please read the bill.
House Bill 18, sponsored by Education, Career Technical Education Funding. Mr. Speaker, your Committee Number 4, Education, to whom is referred House Bill 18, Career Technical Education Funding, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Andrew, Bratton, Erickson, Gugumas, Kelly, Lawley, Strzok, Williams. Excused, Representative Singh. Representative Andrew, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred House Bill 18, Career Technical Education Funding, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Alamand, Angelos, Bear, Haroldson, Pendergraft, Sherwood, Smith. Representative Bear, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Andrew?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 18 do pass. And I turn over the explanation to the good Vice Chair of Education.
All right, Representative Lawley.
Thank you, Mr. Chairman. I bring to you, body, the House Bill 18. This is going to be a little faster, I hope, than the last one. This is another bill on career and technical education, what we call CTE. Remember, a few days ago, we had a bill that was a grant that we had used to try to manage some issues for smaller districts, which was helpful. But we are still looking for some solutions to that problem. And I'll give you a little bit of information here in a moment that will help you understand kind of the disparity and why this problem needs the work it needs. And this bill, quite frankly, doesn't quite get it there, but it gets us a little further down the road. So what this does is it makes an adjustment in the block grant model, providing a sort of a floor, or if you will, raising that floor actually of what a smaller district can get for supply, equipment and supplies. So we'll look at the bill more closely in just a minute, but what I'd like to talk to you about is the disparity between larger districts and smaller districts and how the block grant model works. So in the CTE area, and this is kind of interesting and might be useful later in our session for another bill coming, that CTE is the only part of our school block grant model that is sort of curriculum driven, if you will. Like we don't have an area of spend this much money on math or science. It's got other types of categories, but this CTE is curriculum driven. And so what we see is that the kind of measure of how amounts of money you get has to do with the number of students in classes. And so when you're in rural areas, the class sizes aren't that big as they are in more urban areas. But the cost for the equipment to stand up the program, to run the program, is the same in Cheyenne as it is where I live, in beautiful Worland. But it's the same price, sometimes more, because the larger districts have the ability really with buying power to perhaps get some of it cheaper. But we can have this disparity for smaller districts. So we're going to raise that, and we'll look at that number in a moment. So there's the minimum goes up. It's going to give a little bit more. So a large district, for example, generates about $275,000 to $500,000 for equipment and supplies for CTE in a given block grant year. So a smaller district, in contrast, gets about $5,000 to $12,000 for equipment and supplies. CTE equipment can be very expensive, especially for up-to-date equipment, which we want our kids to learn on equipment that they will find out in the workplace when they get out there. So that's the problem we're addressing. And so what this bill will do will kind of help equalize that. How does it do it? Well, it really does something into the block grant model. You're going to see, I'm going to go through the bill with you now. And it's not till you get to page 2, you see the first changes. And page 2, lines 1 through 4, really are dealing with updating language. We used to call this area, many of you may remember, vocational education. So this statute will still use those kinds of terms, which really are what we're using now in the education area. So you're going to see, actually what I just referred to also relates to the right citation and statute that we're amending here, where you'll find the model information. So then on page 3, I think is where we get to the VOAG. I'm sorry, I got ahead of myself there. So again, page 3, you'll just see a couple of places where we're going to begin to conform the language to the career and technical education versus using the term vocational education. You'll see that conforming amendments for that on page 4 as well. And then on page 5, we get to what this bill does. You'll see that the model currently was just an amount that they could get. So the greater, and we've added and changed the way the grant model is going to work, that a small school district would get the greater of $9,428.77 per FTE, full-time equivalent, in other words, a full-time teacher position in career and technical education, or $18,857.57 for equipment and supplies. So basically, that raises up the floor to that $18,857.57. And this is a change we're making in the actual grant block model. So it will carry on. So we can continue to manage this distinction between larger districts and smaller districts. So that's what this does. And again, it's very needed. It doesn't, I'll be honest with you, it doesn't get us far enough, but it gets us a little bit further down the road to help smaller school districts have CTE programs, be able to provide the type of education that our kids need, their parents want, and the jobs in Wyoming are begging for, the employers in Wyoming. So again, I ask for your favorable consideration, Mr. Chairman, on House Bill 18. I'll stand for questions.
Question being called. All those in favor of Chairman Andrews' motion and with the Committee of the Whole rises to report, it do so with the recommendation that House Bill 18 do pass. Those in favor, please say aye. Aye. All those opposed, no. No. House Bill 18 is passed the Committee of the Whole. The next bill for our consideration is House Bill 172. The reading clerk will please read the bill.
House Bill 172, sponsored by Representative Haroldson. Repeal gun-free zones and preemption amendments. Mr. Speaker, your Committee Number 1 Judiciary, to whom is referred House Bill 172, repeal gun-free zones and preemption amendments, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Brady, Bratton, Filer, Kelly, Lean, Singh, Washit, Webb. Noes, Representative Chestick. Representative Washit, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Washit?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, to do so with a recommendation the House Bill 172 do pass. And I further move the adoption of the Standing Committee amendment. I will introduce the amendment in a few moments. We'll let the sponsor of the bill present the basis of the text of the bill first.
Representative Harrelson.
Thank you, Mr. Chairman. So folks, today we have House Bill 172. This is not a new bill to the House. It's a new bill, obviously, for some of our freshmen, but this was last year's 125, the repealing of gun-free zones. So if you look at the bill, it's very similar to the last year's bill, and I'll give you kind of just a 30,000-foot view of it. This is basically two different sections of this bill. The first section, Section 1, is a new section, and it's created to read that this applies to, if you go on page 2, line 11, 13, and 16, those are three headings, any meeting of a government entity, any meeting of the legislature or a committee thereof, and any public building not otherwise prohibited under Wyoming Statute 6-8-104T or regulated under this subsection. So what that is saying is that you can conceal carry, constitutional or with a permit, in state, local, county owned facilities, anything that basically federal funds touch. This is not having to do with concealed carry permit only. This just has to do with constitutional carry or concealed carry. The second section, which starts on page 2, line 20, actually only applies to the concealed carry permit, and that as well on page 3 has three subheadings, II, and III, and that addresses any public school, public college, or university athletic event taking place on public property that does not sell alcoholic beverages. If you remember from last year, this was brought in because we did not want University of Over the Hill, that one, where we have alcohol being served. We did not want that to be a place where we would have an issue, and so we put that sells alcoholic beverage line in there. II, any public elementary or secondary school facility, and III, any public college or university facility. So this, again, is not constitution carry. This is concealed carry permit required carry. And then, so those are the two sections we're talking about. And then below that, on page 3, line 10, you'll read, nothing in this section shall be construed to. Now, as you're reading that, especially to our freshmen, they'll use that language and then put a list underneath it that if you just read the list without that language would be confusing. So what we shall not construe to allow the carrying of a concealed weapon where otherwise prohibited under Wyoming Statute 68104T. That's going to be on the federal level. And then 2, prohibit a private property owner from restricting firearms on his own private property. Private property, if you have a business and you don't want a firearm on your business, that's your right and prerogative. Just as much as the firearm owner's right and prerogative is to go in or not go into your facility or your establishment. The III, prohibit a government entity from prohibiting the open carry, display, or wearing of a firearm into a meeting of that government entity. What does that mean? That means that while we're here on the floor of the House and someone said, well, I want to be able to open carry into the Capitol and I want to stand up there as we're doing a contentious vote and let everyone know that I'm open carrying and that I'm watching. Well, that's intimidation. That's not defense. That's intimidation. So that we've given that ability for rulemaking. And then under subsection 4, allow the carrying of a concealed weapon to a facility where otherwise prohibited by law. And then it goes on to subsection 5, page 4, allow the carrying of a concealed weapon within a state agency operated health and human service setting, health and human service facility that are licensed by the Department of Family Services, or health and human service facility that are certified by the Behavioral Health Division of the Department of Health to provide residential services. These are things that were brought to our attention over the last 2 years, addressing a meeting of a family in the agency that takes care of the broken families in our community. I'm trying to say it all without the acronyms, guys, sorry. And this is just to protect those areas. And you'll see that in just a minute that amendment's going to address one more thing. And then in 6, allow the carrying of a concealed weapon within a facility where explosive or volatile material are present. This was brought to us by our higher educational institutions, and they're saying, hey, we don't want it to be a deal where someone carries a weapon into a position where there's a volatile material that could explode and level a place. I did further describe that, and you'll see that on page 12 through 16. For purposes of this paragraph, explosive or volatile material shall not include materials that are either in insufficient amounts or in a form that is that the material could not reasonably cause serious bodily injury due to the material's explosive or volatile nature. Because it was brought to my attention that like a permanent marker is considered a volatile material, and we wanted to just clarify this is not what we're talking about. And then on page 4, line 18 through the end of the page, that's kind of the teeth of what would happen if someone were to deny a person their rights in this way. And then moving into page 5, line 4, we brought the language back in for the school's ability to arm teachers and have a training program for them. That's going to be F, I, double I, and then continues on with A, B, and then G. I did put in there as well, though, if a school board chooses not to create a program, that does not give them the ability to deny access for their faculty or staff just on the basis they did not provide a program. And then moving on to page 7, section 2, this is just stating that the legislature of the state of Wyoming has the authority to regulate this, and that's also where we see some of our preemption language. And then page 8, the end of it, we get to see the repealer subsection, as well as kind of section 4 and 5 is effective date, as well as time for the building commission to promulgate rules. So, and with that, stand for any questions.
Chairman Washut.
Thank you, Mr. Chairman. Let me just walk through the standing committee amendment. If you turn your bill to page 4, line 5, at the sponsor's request, we included the Department of Corrections into that list. On page 4, after line 16, we included some additional language that nothing in the bill would be construed to prohibit. That nothing in the bill would be construed to prohibit a governmental entity from A, enacting reasonable rules pertaining to the safe storage of firearms when not being carried on the person of the employee or student. This was particularly important to our residential housing on campus at the colleges and university, that when the gun is unattended, they want it to be secured so that a student who is less familiar doesn't inadvertently be curious and pick it up. Also, that under B, that a governmental entity would not be prohibited from enacting rules pertaining to the safe handling of firearms when not being carried on the person or the employee of the student. So if they are, playing quick draw or doing some type of unsafe handling of the firearm, that could also be addressed by the rules of the local entity. And C, enacting policies that restrict a particular person from bringing a firearm into a disciplinary proceeding, expulsion hearing, or similar meeting. So if the employee was going to be fired, the letter telling them to come to the CEO's office or human resources could dictate that that meeting would be a gun-free zone. It'd be specific to one individual and not carte blanche to society at large. And then on page 4, line 19, after the word person, we delete the word to and insert for, then delete carry and insert carrying. On page 6, line 2, we delete subject to, and on line 6, line 3, delete approval by and insert in consultation with. So that it's not law enforcement that's making the approval decision, but rather that they will be part of the consultation about that decision. And then on page 8, line 17, committee felt it was important due to the constitutional nature of this bill that we originally it said delete or to be effective immediately, but also because of the significant changes that will occur at some of the affected governmental entities, that there will obviously be some time needed for training, for policy changes. Some may have to go before a board of trustees for changes to the policies to comply with the statute. So we moved the effective date to July 1, 2025. And that's your standing committee amendment. Stand for questions on the amendment.
Thank you, Chairman Washut. We're on the standing committee amendment. Representative Filer.
Thank you, Mr. Chairman. I think I'd like to divide this amendment. I believe I would like to say Division 1 would be line 16 through 18, that part C. And then Division 2 would be everything else.
The chair rules that divisible. Which division would you like to go first?
I would like to go with, we could probably just get Division 1 or 2, I'm sorry, 2 out of the way.
Okay, Division 2.
All right, and the reason why, everybody, that I bring this division is just that there was probably, in our committee, there was a little complication of, if this was completely germane to it, or if it went a little too far, maybe took away from what the actual bill does. So when we look at Division 1, it just enacting rules pertaining, Division 1. I agree with A, B, but C is just, I don't know. It's just not, I don't know if it's germane to what, I think it just goes a little too far. So if we want to go with Division 1, Mr. Chairman, would it be okay if I drew this one up real quick and just got a little bit better prepared? And just withdraw this amendment real quick, and then I'll redraw it the way I like.
Right. Division withdrawn.
So I withdraw that real quick. I'll be back.
Question on the amendment.
Representative Pepperson.
Thank you, Mr. Chairman. So as we look at it, I'll just talk a little bit on the amendment. I think that the carry or the handling and the storage concept is a great addition. That is an area where we can avoid unnecessary or unintended consequences, I feel. So I think that's those three ideas there are really solid. That gives us the opportunity to give the facilities that have dormitory options and those types of deals the option to just say, hey, we're going to protect students and faculty by just making sure that they understand where they can, how they can handle that firearm and as well as how they can store that firearm. I also think that the first language you see, that's cleanup that's been brought to us by our law enforcement, excellent. I think that that's really good. The enacting date, that's a decision you guys can make. Obviously, immediately, what's rights? I mean, is there a date on our rights? But at the same time, we also understand that they're going to have to promulgate rules, and so I'm not. That's not a hill I'm willing to die on or I'm going to die on, but it's just a policy. You guys have to decide what you think is best. So the concept of prescribing those, carrying them into a disciplinary action or a hearing, that's a decision. I did some research after, I haven't seen proof that that's been an issue. I haven't seen where it's like, man, we've had issues because of this. So I would tend to lean maybe a little less in favor of that. So those are kind of my heart on this amendment.
Further discussion on the amendment? Representative Filer?
Thank you, Mr. Chairman. Now that I'm all straight now, and just to piggyback off of the bringer of the bill, but that I do believe that part C. So did I do line 16 through 18? Was that Division 1? Is that correct? So on that Division 1, that line 16 through 18, or did I say I want to do Division 2 first? Oh, I withdrew, didn't I? Oh, never mind. Mr. Chairman, I would like to divide the amendment.
Proceed.
Mr. Chairman, I would like to make Division 1, lines 1 through 15, and also lines 20 through 31. Now that I'm squared away.
And that's Division 1.
Okay, and Division 2 would be, of course, lines 16 through 18.
Okay, Chair rules that divisible.
Okay.
Proceed.
Mr. Chairman, now that I got all my ducks in a row here, I think I'd like to work on Division 1 first, to be exact. So I believe those, just like the other speaker was mentioning about, the rules pertaining to safe storage of firearms, I think there could be some good policies on that. That way a student doesn't leave a, firearm just sitting there on their desk and another student grab it or whatever it might be. The rules pertaining to the safe handling and all that with visitors. I totally understand making rules for that. And also all the way down to July 1st. The reason why we did July 1st in committee was the fact that, maybe some places up over the hill and some other places might need to make some policies, get everything, at least, maybe some public input, comment, and then throw some stuff out there before we just enacted the law. So with that, I would support amendment or the first division of the amendment, Division 1 of the amendment.
We're on Division 1. Discussion on Division 1. Chairman Washit?
Call the question.
Question having been called on Division 1. All in favor, please say aye. Aye. All opposed, no. Division 1 is adopted. We are now on Division 2. Representative Filer.
Yes, Mr. Chairman. Division 2, this is the one that I was having a real, I could go back and forth on that in committee on if we wanted to keep this. A lot of places, they bring in policies and stuff that there's disciplinary action. They do it off property most of the time. I know in my professional career, they always did it off property. And then, of course, those places have their own rules and policies within that. So I don't know if, I've never heard of, except for maybe one time in our nation's history where we've seen something, disgruntled from our employee from a disciplinary action possibly. So I don't know if it's really needed, Part C, but, vote your conscience on that. But I would say that, Part C is, in Division 2, I'd like to not support there, Mr. Chairman.
Discussion on Division 2. Chairman Washit?
Well, I just ask the body to think about a situation where an employer has had an employee who's made violent threats towards a coworker or student or others. It seems reasonable that that employer or a dean would not want that student or employee to come to that disciplinary meeting while armed. This is way different than having a blanket prohibition saying no one can carry a firearm on our campus or in our government building. It's simply saying this is a person who, for cause, we don't wish him to be able to bring a gun to the meeting. Lots of our institutions do the disciplinary hearings on campus or in their buildings. So this just seemed like a reasonable provision for these employers, for the deans, to keep someone who, especially someone who's made a violent threat, to not be able to invoke this statutory authority to bring a gun into that meeting. So that's all the reason for this, very specific to an individual who they feel should not be armed at that meeting.
Representative Harrelson.
Thank you, Mr. Chairman. One thing I want to talk about, kind of the elephant in the room when it comes to a Second Amendment bill, is how do we go through this without getting heat? And I just want to tell you, like in this situation, this is just conversation about the policy. So if you vote for or against this, I want to just tell you right now, I will personally go and defend any one of you if someone were to come out against you on this amendment. This is not one of those things. This is just, as the good chairman said, a good policy conversation, which I appreciate the good representative from the capital city that brought that split to just have this conversation. But I think that really you have to ask yourself, have we seen this to be an issue? Yes or no? And is this a good decision, and is this a good policy? I think it's a good carve out to just have that conversation and wanted to bring that forward. So personally, I don't believe this is a need, but I also sit there and understand why it was brought, and also don't see it as being overly bad. I just don't know if it's a need. And so I think it's good to just have the conversation and think about, as we talk about that balance of rights with that balance of intelligence for protection and what that looks like. And so, like I said, either way, I don't think this is contentious. I think it's just a good conversation. Thank you.
Representative Clouston.
Thank you, Chairman. I just want to be clear for everyone here. I believe an I vote is removing these two lines, and a no vote is keeping those. I just want to make sure that is correct. Thank you.
The way I understand it is, if we vote aye, we adopt Division 2. If we vote no, then we defeat it. Thank you for clarifying. Chairman Washington.
Thank you, Mr. Chairman. So one reason maybe why we haven't seen this is because many of these places already prohibit firearms on their campus or in their buildings. And so no one is coming to those meetings saying, hey, state law tells me I can bring this gun into this meeting. Once we pass this law, that may happen, where an employee shows up and says, you can't keep me out of this meeting with my firearm because state law now says I can bring my firearm into this termination hearing. So, you know, those are obviously very volatile situations rather than just day-to-day activities. I think it's reasonable to give our employers and deans these types of rule-making authority.
Representative Filer.
Thank you, Mr. Chairman. I have no heartburn either way. I just thought in committee that I think we needed a larger look at it with the body here. So, you know, I have no heartburn either way, which way we go on it. I totally understand both sides of this. But I thought it was better to bring it all to all of us instead of just making that decision, dividing it in committee. So that way we all had a chance to at least look at it and decide that for, I like a lot more input is all. Thanks.
Question being called. We're voting on Division 2 of Standing Committee Amendment. All in favor of Division 2, please say aye. Aye. Those opposed, say no. No. Division number 2 has failed. All those in favor, please stand. Stand up or sit down, not both, please. Those opposed, please stand. On a vote of 29 to 26, the amendment has failed. We are now on Committee of the Whole, Amendment Number 1. Representative Chestick.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 1 to House Bill 172. And this, it's a simple amendment. I'm simply adding a paragraph to the bill and you can all read it. It basically requires anybody who wants to conceal carry into a school building to stop at the front office and identify themselves, to tell school officials that they are carrying a weapon into the building, and to identify their name, contact information, and the type of weapon they're carrying. A couple of reasons for this. First of all, I believe it provides a measure of safety to the person who is carrying the weapon. So that it makes it easier for, if things go sideways at some point during the day and law enforcement is called, it might help identify who's a good guy and who's a bad guy. So that, I think, it presents a measure of safety to the person carrying. Also, the people in the building ought to know if there is a concealed weapon in the building. I think that is a reasonable request. Also, I believe it would help if things really do go sideways and the gun is discharged at some point. It can help with the forensic analysis, which will have to happen afterwards. So for that reason, I ask for your favorable consideration of this amendment.
Representative Harrelson.
Thank you, Mr. Chairman. On and against this amendment, I think one of the things that we need to understand, the beauty of concealed carry and the concept behind it is that our goal is that it's a mode of defense, but you're not in the place where that's open policy or knowledge. We've seen, I actually had an individual approach me that was part of another state and that had done it a different way. And they made it this way where they had to actually inform, and that was used, it was weaponized actually against that individual. And so that information can leak. There's just, at the end of the day, if you have a concealed carry permit issued by the state, we'll say that, then you're already in a position where you are abiding by the law. You've already gone through a vetting process. And at this point, there's no need for this to move forward. So on and against this amendment.
Further discussion? Question being called. All those in favor of Committee of the Whole Amendment Number 1, please say aye. All those opposed, no. No. Committee of the Whole Amendment Number 1 has failed. We're on Committee of the Whole Amendment Number 2. Representative Chestick.
Mr. Chairman, I at this time withdraw Committee of the Whole Amendment Number 2. Don't get your hopes up too much. I'll be back tomorrow with a better and improved bill.
Committee of the Whole Amendment Number 2 has been withdrawn. We're on Committee of the Whole Amendment Number 3. Representative Campbell.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 3 to House Bill Number 172. And would like to, before talking through this amendment, give you a little I don't know, background as to how I got here. So first, serious kudos to the bringer of the bill. Truly appreciate the work and effort in making this much better than previous versions. Very well done. So I stand here, I mean, truly, I'm honored to represent House District 56 and am committed, absolutely committed to doing right by them, right? So a year ago, when the first iteration of this bill came through, it was making its way through the House and through the Senate. I reached out to our chief of police, I reached out to our sheriff, I reached out to our high schools, our students, our teachers, our principals, reached out to our community college, reached out to our hospital, reached out to our courts, and I asked the question, what happens if this goes into effect? What does that look like? All of them said, this is horrible. This would do really, really bad things. So I stand firmly with them today in opposition to this bill. I also stand firmly in favor of and in support of the Second Amendment with the bringer of this bill. You might say, well, how is that possible? How can you do both? So imagine, I mean, hypothetically, Mr. Chairman, I invite you to dinner at my home, okay? I know, I am aware that you own and carry. And so I explained to you that I am not comfortable with firearms in my home. And then I respectfully request that for that evening, you leave it out in your vehicle, you leave it at home. Now, being the owner of that property, what do? You would respect my right to make that decision. Might leave it out in your vehicle on the street, come in, we have a great dinner, right?
Point of order.
Getting there.
What's
Thank
your
you.
point?
The point is.
Mr. Speaker, we are on the amendment.
We are on the
We're
amendment.
not, Mr. Chairman, pardon me. I don't believe that crosstalk is permitted. You granted me the mic.
Point of order, please. Yep.
Thank you, Mr. Chairman. We are on the amendment, not here to listen to dinner invitations or fear of firearms. If we can stick to the amendment and the line numbers, that would be great.
Point taken. Let's bring it into the bill, please.
Yes. And apologies for the cross. That was my bad. So my point of the amendment is this bill is not a Second Amendment bill. This bill denies local authority, and that's the challenge I have with it. Because what this bill does is dictate that the state government can tell our cities, our counties, our school districts what they can and cannot do on their property and in their buildings. That's where I have a challenge, because we are denying their right to decide in their home. So Amendment 3, as an overview, simply goes through, starting on page 1, line 2, and throughout the document through page 37, alters anytime we see the word government, changes that to state government. So it does not affect the rights of our cities, our counties, to make that decision. Also on page, let's say, starting on page 3, I believe. Yes, on page 3, line 1, where it says any public school or public college, we just inserted that is owned by the state or on state land, right? Giving the state government the authority to make that decision for itself and not denying the rights to our cities, counties, and school districts that may own those buildings or those properties. Moving on to, I think, continuing on through page 3, anytime we see the word public, we're just going to insert the word state, making sure that we are clear this is state-owned, state decision to make. And then page 4, line 16, where those repeals have been inserted, I have to find it now. Page 4 through 16. Is that where I'm at? After line 16, where those repeals are going in, we will be, no, I'm on the wrong thing. Hold on. Hold, please. She did a really great job of lining this out for me. Now I'm messing it up. Where the repeals take place, governmental 318. Hey, thank you. Page 8, line 9. Yes, please, thank you. Okay, so page 8, line 9, in those repeals, we are deleting that and inserting wherever it has government, just replacing it with state. So if it is owned or operated by the state, then that will stay intact. On page 5, nope, I'm past that. Anyway, that's the essence of this amendment, is to make sure we are clear that in terms of making that determination as a state agency, yes, the legislature gets to decide as a state agency, but it is not okay for the state to then dictate to our cities, our counties, our school districts what their rights are or take those rights away from them. So to ensure we don't have that government overreach, I present Amendment 3, just so we're clear.
Representative Harrelson.
Thank you, Mr. Chairman. So Wyoming Statute 6-8-401 is our preemption status in the in the Green Books. And it says in A, the Wyoming legislature finds that the right to keep and bear arms is a fundamental right. The Wyoming legislature affirms this right as a constitutionally protected right in every part of Wyoming. And then it continues on under C, the sale, transfer, purchase, delivery, taxation, manufacture, ownership, transportation, storage, use, and possession of firearms, weapons, and ammunition shall be authorized, regulated, and prohibited by the state, and regulation thereof is preempted by the state, except as authorized by Wyoming Statute 15-1103 and 21-3-132. But then it goes on and it says, no city, town, county, political subdivision, or any other entity shall authorize, regulate, or prohibit the sale, transfer, purchase, delivery, taxation, manufacture, ownership, transportation, storage, use, carrying, or possession of firearms, weapons, accessories, components, or ammunition except as specifically provided by this chapter. What we have in the preemption is the fact that it is not the local control over the Second Amendment conversation. Furthermore, this bill does not tell you what you can and cannot do in your house. And I also need to push back a little bit. We had the first amendment that you guys passed, the Standing Committee Amendment, actually put in the language that was asked for by the group that represents our law enforcement, saying, hey, these are a couple things, if you could put these in, that's our concern. So to say that everyone is afraid of this or concerned with this or thinks this won't work, we didn't hear that in committee, nor is that standing as truth. And so our preemption statute goes against the very concept of this, as well as our Constitution, and also testimony did not align with this being the need or the status of what we need to do with this bill.
Chairman Washington.
Thank you, Mr. Chairman. We had this conversation about local control. And the big challenge for me with local control is when you look at this Article 1, Section 24 of the Wyoming State Constitution, the right to bear arms, like I said, is Section 24, so it's right in the middle of all these other rights. Things like freedom of speech, freedom of the press, jury trials, due process of law, treason, free and equal elections, and all these other rights guaranteed right in that same section. And every one of those rights are applied statewide. they're not subject to local control. Even if local conditions are different, search and seizure on the western side of the state, search and seizure on the eastern side of the state dealt with exactly the same. Same thing with water, same thing with free speech. So it's really hard to, in my book, constitutionally, to sustain an argument for local control on a constitutionally guaranteed right.
Representative Pendergraft. Representative Campbell.
Thank you, Mr. Chairman. Absolutely appreciate, right, the intent. And to the bringer, in terms of reference to 68401 and the preemptive authority of the legislature, that does apply to the sale, transfer, purchase, delivery, taxation, manufacture, ownership, transportation, storage, use, and all of those things, except as authorized by 15.1.103. 15.1.103 is the governance and the authority to govern and make those decisions, the general powers of governing bodies. That's what 15.1.103 is. Giving our cities, our counties, our municipalities the right to govern and to make those decisions. So our city can determine whether or not firearms are allowed in City Hall. That's what 15.1.103 does. That is my understanding. Thank you.
Further discussion on Committee of the Whole Amendment number 3. Question being called. All those in favor of Committee of the Whole Amendment number 3, please say aye. All those opposed, no. Committee of the Whole Amendment number 3 has failed. We are back on the bill. Representative Chestik.
Thank you, Mr. Chairman. I have a lot to say. I think a lot of you who were here last session know how long I can go on this, and I will try and make it much shorter today. But there's a few points I do want the body to consider as we consider this bill. First of all, I just want to remind everybody that we all agree on one thing. We all want safer schools. Everybody here wants that. Including we've had emails from constituents on both sides. Everybody wants the same thing. The only question here is, what is the best way to get there? More guns or less guns? It's that simple. Do we want more guns or less guns in schools? To me, the answer is pretty straightforward. Fewer guns means fewer bullets, fewer people getting hurt. I am not at all persuaded by the idea that a gun-free zone is a safe target. That is something that is testable and through empirical research. And at the committee meeting yesterday, we had a lot of testimony about several different studies, one of which I thought was junk science, and the author was not credible at all. The other one was a peer-reviewed article published in a top medical journal, which concluded that gun-free zones are safer. There is less gun violence in gun-free zones than in a non-gun-free zone. That's a peer-reviewed article, and it sounds like common sense to me. Fewer guns means less gun violence. One of the things I want to point out is that our constituents don't want this. You've all been bombarded with emails, a lot of emails on both sides. I find the emails that come from actual Wyoming residents who identify themselves are more credible. But also public polling has shown that public doesn't want this. The public does not believe that guns in schools make schools safer. And it influences the learning environment, makes it a scarier place to be, and it harms the environment. Yes, we have a Second Amendment, and I'm a supporter of the Second Amendment. It's in the Constitution, and I think it has a place, and I totally support the Second Amendment. But no constitutional right is unlimited. There's limitations on every constitutional right. Sometimes constitutional rights conflict with each other, and you have to pick which one is to be enforced. But the Second Amendment actually says in its own terms that regulation is possible. A well-regulated militia being necessary for the defense of the country. Well-regulated is in the Second Amendment. So it automatically, on its face, admits to regulation. Gun-free school zones have been held to be constitutional when measured against the Second Amendment. That great left-wing radical Antonin Scalia, in the Heller case, said, yes, gun-free zones in sensitive areas like schools are constitutional. We can regulate guns in schools. We should regulate guns in schools. For that reason, I am opposed to this bill and would ask for a no vote on this bill. Thank you.
Representative Conley.
Thank you, Mr. Chairman. I'll probably vote for this bill, but with having gone through quite a bit of active shooter training because of my job, I'm just real nervous that at some point, when law enforcement goes in and does what they need to do, and I've talked with my law enforcement, that somebody's going to get hurt more than would need to have happen, because when they go in, they're going to shoot whoever they see has a gun. And I'm just nervous about that. I'm nervous about what kind of chaos can be if you've got a basketball game going and you've got 50 people in there with concealed carries and everybody starts shooting. Now, maybe that's unrealistic. I don't know. But based on the training that I've had, I think it's a possibility. And I feel bad for law enforcement being put in that position. And the other thing is, with our schools, I wonder if there shouldn't be something there that gives them some immunity against exactly what I'm talking about. Immunity and what their liability costs are going to be when this probably passes. Those are just my comments. Thank you.
Representative Kelly.
Thank you, Mr. Chairman. I too was in that committee when we talked about this. I'd like to refer to the first, the research, and I apologize ahead of time. This may be the most you hear me speak the entire session. I agree that some of the research that was brought in to testify in favor of this bill was shoddy. It's not something, as I'm someone who peer reviews journals myself. I work at a university. I've written peer-reviewed articles. I teach statistics and research methods, and I understand that some of it you could categorize as junk science. That said, having worked on these types of things myself, looking at the numbers from the study that did conclude shootings are less likely in a gun-free zone, they misinterpreted their own results. They reported in their own data, out of 150 incidents, 48% happened in gun-free zones. Is 48% of this country gun-free? Not even close. So you know right there that a shooting is much more likely to happen in a gun-free zone, because if gun-free zones make up significantly less than 48%, yet still make up almost half of the shootings, based on the numbers of the people speaking against this type of bill, then whether you use the junk science or the peer-reviewed science, it still points the same direction, that people are more vulnerable in gun-free zones. I'd also like to point out historically, if we want to talk from an idea of common sense, that two things happened around the year 1990. One was schools became gun-free at the federal level. Second, states began passing concealed carry laws. And the trend after that, and I understand that correlation is not causation, but you can still look at the trends and see that as state after state passed concealed carry laws, violent crime dropped in the country. And the era of school shootings began during the same time, and they became infamous. Now, this is coming from somebody who's a former public school teacher who taught in the state where there was horrific shooting at the end of the 1990s that also happened during our assault weapon ban. And I spoke to other educators, and we had serious discussions. Would we rather face potential violation of the law and carry inside the building to protect our students and ourselves, or we'd like to take that risk and leave them in our car? I chose the latter. Other teachers did not. If you think those gun-free signs are keeping guns out of schools, they are not. Now, beyond that, I'm also a father. And I spoke about my son yesterday. He's one of the most vulnerable people in our state. I shudder to think of how defenseless he is. And I shudder to think about how many teachers in the last few decades have literally given their lives to protect their students when they shouldn't have to. I stand in favor of the bill.
Representative Filer.
Thank you, Mr. Chairman. Just a little background. 5 legislatures ago, there's a similar bill that came to this body. And that bill allowed for repealing of the gun-free zones in our schools. That was it. I couldn't support that bill. I wanted to amend that bill then to allow for all of our state buildings, including this Capitol. So we're not just talking about schools. We're talking about all of our government buildings, all of our state buildings. So that's why I jumped onto this bill, because it is actually more broad. It allowed us, to exercise our rights, to our constitutional rights to life, to protect ourselves. And I think that's the biggest point we need to make here with this, is when there's a soft target, a gun-free zone, things of those natures, people are going to go to those places because they know they're defenseless. And we're talking about somebody that's an enemy of the state at that time because they're on suicide missions. They don't care who they hurt, who they kill. But we're taking away the constitutional rights of life of our citizens, of our teachers, of the people in this building and every state building we have. We have a right now in Wyoming where we can walk around our streets, open carry, concealed carry, because we are allowed to protect ourselves and arm ourselves. But we keep having these restrictions that would eliminate those rights. I can tell you right now, I feel way more safe, even in this building, if I knew that maybe a few of us are armed. There was also a question brought up about law enforcement. They won't know who to go after. But I do believe that gun ownership comes with responsibility. If there was an active shooter situation and somebody had to protect somebody else, I'm pretty sure once law enforcement got there, they would be smart enough to hit the ground, drop their weapon, so that way the law enforcement knows. Because that's survival, right? And it's a natural instinct that we have is to survive. Let's not take away our constitutional right to life and our constitutional rights to protect our families, to protect our friends, and to protect the citizens of this state. Honor for this bill.
Sensing your urge to vote, Representative Harrelson.
Question.
Question being called. All those in favor of Chairman Washington's motion that when the committee of the whole rises to report, do so with a recommendation that House Bill 172 do pass, please say aye. Aye. All opposed, no. House Bill 172 has passed the committee of the whole. Mr. Majority Floor Leader.
Thank you, Mr. Chairman. So those first 5 bills took us over 3 hours. So the next 5 bills we have is 169, 116, 50, 51, and 121.
Oh, Mr. Majority Floor Leader, our clerk's asked that you repeat that. Thank you.
Okay, the next five are, it's on the list, is 169, 116, 50, 51, and 121. So no changes, just the next five.
Thank you, Majority Floor Leader. The next bill for our consideration is House Bill 169. The reading
Mr.
clerk-
Chairman, if you wouldn't mind, Mr. Chairman,
Yes, Speaker Nyman.
just to give you folks a slight break here, there are some men that have been waiting up here in the South Gallery for a few minutes, and I would like for this body to recognize them. If you good gentlemen would please stand. These are the folks from the Wyoming Stockgrowers Association. These are the folks that are helping us build food and fiber for this great state and nation. And standing up there is Jack Berger from Saratoga, Wyoming. He's your Wyoming Stockgrowers Association president. Reg Phillips from Du Bois. He is your first vice president. And as you all know, the gentleman in the middle, he's the creamy filling up there, Jim Magagna from the Wyoming Stockgrowers president. So if you could please recognize these men. Thank you, body. We appreciate what you gentlemen do.
Mr. Chairman.
Thank you. Yes, Representative Garinger.
Thank you, Mr. Chairman. Privilege of the floor.
Please.
Mr. Chairman, members of the body, I'd like to recognize some students that we have in the West Gallery from Central High School. Some of you may have been pulled aside in the lobby to have them talk to you about some bills that they're interested in, and I would just encourage us all to recognize the effort and the work that they're putting in to exercise their rights. So thank you for being here.
Welcome to the House. Representative Larson.
Thank you, Mr. Chairman. In our West Gallery back here, we have Sweetwater County Commissioner Taylor Jones sitting up in the gallery. Just like to welcome him to the House.
All right, we'll keep rolling here. The next bill for our consideration is House Bill 169. Reading clerk will please read the bill.
House Bill 169, sponsored by Representative Locke. Homeowner Tax Exemption 2025-2026. Mr. Speaker, your committee number 3, Revenue, to whom is referred House Bill 169, Homeowner Tax Exemption 2025-2026, respectfully report same back to the House with the recommendation do pass with the following amendments. Ayes, Representatives Brown, Campbell, Lean, Locke, Lucas, Riggins, Stivar, Wharf. Noes, Representative Storer. Representative Locke, Chairman. This bill was re-referred to Committee Number 2, Appropriations. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred House Bill 169, Homeowners Tax Exemption 2025-2026, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Alaman, Angelos, Bear, Haroldson, Pendergraft, Smith. Noes, Representative Sherwood. Representative Bear, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Locke.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 169 do pass. And I further move the adopted Standing Committee amendment. And I will present the bill myself. And I would like to actually go through the bill first, and then we'll get to the Standing Committee amendment. I think that'll make it a little clearer for everyone to understand. So to start with, a large number of us were sent here to deliver tax relief and reform, and ultimately tax reform to Wyoming families. This bill is short-term relief for a large swath of our residential taxpayers to fix excessive increases to a property tax burden that our families have seen in the last several years. The people have been very clear that it is a priority, evidenced by the People's Initiative to get tax relief and reform in place. This bill is focused on leaving some money on Wyoming families' kitchen tables. We are here today because we refuse to give broader tax relief to cover this bubble in the last couple of years. I would like to kind of summarize the bill just a little bit, and then we can go through it fairly quickly. But I want to hit the highlights because I think it'll be easier for you to see it in the bill if I take this approach. So I'm going to summarize the bill and just hit the highlights. But basically, this is a 50% tax exemption against the fair market value of a broader range of residential properties. It only applies to the first $1 million of the fair market value of a home, and it only applies to residential structure, so it does not include the land. It also has a 50% backfill to counties and municipalities, and then to support that backfill, and these are a bit out of order in the document, but we'll get to that. There's a $125 million appropriation from general fund and $100 million support from the Legislative Stabilization Reserve account to support $225 million to support the backfill. And then finally, one of the things that you'll see in this bill, and I'll go through it fairly quickly, but you'll see where it happens in the bill. This is really just designed to ensure relief in 2025 and 2026 for tax relief. The goal is also to ensure no conflict, and you'll see that once I get to that paragraph in the document, or in the bill itself, to ensure that there's no conflict with the People's Initiative and that we're not impacted by 2224 319A Romanet 3. But I'll talk to that in a little bit more detail. So let me just go over the bill fairly quickly so you know where these items in the bill are so you can see what you're looking at. And hopefully that'll help a little bit. On page 2 of the bill, that 50% tax exemption, you'll see that starting at lines 8 on page 2 in paragraph A. The amount of the exemption of this paragraph is 50% of the fair market value of a residential property. Moving down in that same paragraph, in paragraph A, you'll see it only applies to the first $1 million. Moving on to paragraph B, you'll see in paragraph B, lines 15 there on page 2, that the residential property means a structure intended for human habitation, including a house. There's more to that text, but the intent is the structure only. Then when I talked a little bit about the backfill, and this paragraph obviously gets a little bit more messy, but when you get into at the bottom of page 2, paragraph C, and really moving on into page 3, and you move partway down the page, you'll start to see language down there around line 11, moving down there. So this is all about how the tax entities will maintain how much taxes reduction they experienced. And then down there, when you get down toward the middle of the page, lines 10, 11, 12, 13, that's where the 50%, you start getting into the 50% backfill. And you'll see also in that paragraph as you move down that it references that there will be some backup to the appropriations from the Legislative Stabilization Reserve account. So you'll see that on page 3. Okay? And then we move on to page 4, and we're still in that paragraph C at the top. And here it talks about 50% of the reduction in the taxes, and this again is related to the backfill, and it makes it clear on lines 6 and 7 that the Legislative Stabilization Reserve account under this paragraph shall not exceed $100 million. So that kind of hopefully lays this out a little bit. And then moving on to page 5, and I know some of these things are going to feel a little out of order. This is where you go to page 5, section 3, and this is where we try to make it clear. This is a 2-year. This is a sunset in 2 years, 2025 and 2026. And then we make it clear down there under section 3 in the Romanet 2, nothing in this act is intended or shall be construed as substantially the same as proposed laws offered by the initiative as provided in 22-24-319A Romanet 3, including the People's Initiative. My goal here, and just so you don't know, that particular statute makes it clear that if it was substantially similar, the Attorney General would have the right then, of course, to try to say no to the People's Initiative. I'll be honest with you, the intent of this bill is we're responding to the people's request that residential property tax relief is needed, okay? And it is certainly not, it is my goal not to conflict with the will of the people. When you consider how much energy was put into that particular bill or that initiative and the number of voters that signed it, it is very clear that the people have spoken. So I wanted to ensure this does not conflict. The other item that is kind of important in this bill is section 4 on page 6. So fairly quickly, this is actually the appropriation out of the general fund, $125 million. So this $125 million and the LISRA are the funds that would be used for that backfill that was discussed. And then, of course, this is enacted immediately upon being passed and signed by the governor. And that is actually the bill. I do want to talk a little bit, just briefly, to the, assuming I can find my own notes, at least. Just fairly quickly, I'll just, so people understand, the fiscal note on this was about $395 million in there, and that's why the 50% backfill is going to be basically 50% of that $395 million. There's a little bit more of that in this potential appropriation, but I was hoping to just at least make sure we covered that 50%. So I wanted that much to be clear on the bill. And now, before I go, we start discussing the bill, I want to bring up the amendment. So I would like to move, since I may not have done that, and I will apologize to the chairman, I'm going to move Standing Committee Amendment 1. Now, we heard in our committee, one of the real critical issues with a lot of these exemptions that are out there, that we want to be careful not to make these, for lack of a better term, too much overlap and collide. There needed to be a clear picture as to what order these exemptions are applied, so it was clear for the department to do their job. So that obviously was a very serious issue, and we wanted to make sure we addressed that. So Standing Committee Amendment 1, what it says, as you guys look at it, all it does is it inserts on page 2, it asserts in the paragraph there, lines 4 through 6, it inserts that after paragraph in line 5, it asserts no person shall receive an exemption under this paragraph if the person receives an exemption under Wyoming Statute 3611-105A 45. Okay, that 45 means nothing to everyone here, so let me help you. 45 is actually the long-term homeowner's exemption, which is already in place, okay? So if a person has requested the long-term homeowner's exemption, they will not experience an exemption under this bill. Okay, so that's what the amendment does. This was requested by the department to make sure we made a clear distinction. We chose this order of these bills because the long-term homeowner exemption gives them an exemption against their residential structure and land. And so we wanted to make sure that that long-term homeowner exemption, it's potentially better for a person who's lived in, and of you who don't know what the long-term homeowner exemption, a person who's 65 years old and has paid property tax in the state for 25 years can apply for the long-term homeowners exemption. So we wanted to make sure that this would not be applied, it would not be doubled, and what we're really trying to do with this is provide short-term property tax relief to a broader set of our customers, which is what we've heard at the doors. Many of us have heard at the doors. And ultimately what they're looking for is from, and this is not it, but they're looking for property tax relief at some point. But right now, this is just giving some initial relief they're looking for long-term reform. This is just giving short-term relief and hopefully gives us time to put what I would refer to as reform in place to make sure we take care of our folks. So that summarizes the bill. I ask for your favorable consideration, but let's go back to the amendment, and I ask for your favorable consideration of that amendment, if you would. So. For Standing Committee Amendment Number 1.
We're on the Standing Committee Amendment. Discussion on the amendment. Representative Lee.
Thank you, Mr. Speaker. I stand in favor of the amendment to make sure that we are not giving people the opportunity to have a 50% or 100% property tax exemption. This amendment provides clarity for the assessors, and it gives our people that are not covered by the long-term homeowners the opportunity to take advantage of the 50% exemption as well. And so we're trying to make sure the tax is fair, but that we also are making sure that we're only using one exemption at a time. If you come up with questions about the 4% would remain in effect, and the assessors would be able to use those. It is also the intent of this amendment that the veterans exemption also be usable, if they so choose, for their home.
Further discussion on the amendment. Question being called on Standing Committee Amendment. All those in favor, please say aye. Aye. Opposed, no. Standing Committee Amendment has been adopted. We are now on Committee of the Whole Amendment Number 1. Representative Storr.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 1 to House Bill 169 and ask for your favorable consideration. Excuse me. Those of you returning from last year know that we debated a lot of property tax bills. And as a member of the Revenue Committee, I played a bit of a hand in them, and with a similar one to House Bill 169. The debate we were having last year really had to do with whether we wanted to craft an exemption that was based on a dollar value and limit that dollar value, or craft it on a percentage value and then create a cap. I'm inspired by the senior legislator from the center of the state yesterday who made it clear that sometimes it's important to have an open mind and change that mind. And so I'm here today to tell you that my mind has changed a bit about these bills that as we work through them and with the work that we've done otherwise. The sponsor of the bill has identified very clearly that the purpose of this bill is to give short-term property tax relief to homeowners impacted by the post-pandemic rise in property values. And I appreciate that. However, this bill really does discriminate against the very homeowners who were impacted the most by an increase in values. Those are the homeowners who have the highest values of their homes and also saw the greatest percentage increase in their property taxes. I'm not talking about millionaires and billionaires. I'm talking about people, average people, who live in the northwest part of the state, especially. People who own an 1,800 square foot house It's 40 years old. And they have household incomes of $80,000. And their property tax is over $10,000 because the value of that home is over $2 million. This describes the average recipient of a Teton County, of the property tax refund program. $10,000 property tax bill, $80,000 household income. So while the average home in most of the state is going to be under $400,000, in Teton County, our constituents are dealing with the fact that their homes are valued at closer to $2 million, a similar home. And thus, that homeowner, because of the $1 million cap, will only receive a 25% reduction in their relief. Thus, as written, the bill provides the least relief to those who have been impacted the most. So it's not fair, but it's also not constitutional. And I'd ask any of you to just turn to Article 15, Section 11 in the Wyoming Constitution that clearly states that all taxation shall be equal and uniform within each class of property. So for this bill to be constitutional, you really do have to remove the $1 million cap and provide a reduction across the board. Now, in committee, we talked about the fact that that would cost a whole lot more. And so I actually think a better alternative is the fact that since we debated these bills last session, we've actually passed Amendment A. We put that on the ballot. That gives us some tools to differentiate between different classes, between new classes of property, and to bring property tax relief in a way that is constitutional and fair across the board. So I'll be bringing a bill that does that. But in the meantime, I would ask that you support this amendment that takes the $1 million cap out and makes it clear that we're at least going to debate a constitutional bill for this body to debate. Thank you.
Representative Bear.
Thank you, Mr. Chairman. I appreciate the previous comments about the constitutionality, but I will point this out. This is Article 15, Section 12, exemptions from taxation. The property of the United States and the state, counties, cities, towns, school districts, and municipal corporations, when used primarily for the government purpose and public libraries, lots with buildings thereon used exclusively for religious worship, church parsonages, church schools, and public cemeteries shall be exempt from taxation, and, here it goes, such other property as the legislature may general law provide. So folks, it is constitutional.
Representative Lean.
Thank you, Mr. Chair. I am opposed to the amendment, and I urge you not to adopt it. For you see on page 2, line 11, it says that this exemption shall only apply to the first $1 million. That is all homes, that is fair and equal. And furthermore, if we are to remove this cap, there is a possibility that the appropriation may get so great that we could offer no tax relief to anybody. Thank you.
Chairman Locke.
Thank you, and let me bring some additional information to that. For example, and yes, that's exactly right. We removed the $1 million cap, and believe me, we would love to give even a broader set of relief. But let me put that in perspective, and so we can just kind of keep the cost, if you will, in a box. It was an attempt to basically provide relief to the broadest group of people. And that's what this bill was designed to do. And when I say the broadest group of people, And the bringer of the amendment, I understand the point very well. But this will give you a perspective. Roughly 96.5% of the houses across the residential properties across the state out of 230,000 are all $1 million or less. Okay? We're talking about the 3.5%. Now, that doesn't mean that there's not an impact there. I don't want that to come across that way because that's not true, and I understand the bringer. But because of that, and us trying to at least give the broadest relief we could and try to keep it within a range of budget, we were at least trying to take that approach. And I do want to thank the two speakers ago for bringing up Article 15, Section 12. The legislature is definitely given a broader, is given a broad latitude when applying an exemption. So I'm on and against the amendment. I think we should keep it the way it is, make sure we can do our best for the broadest group of people, short-term relief, and ultimately try to bring the right things, do the right thing for the Wyoming people at the broadest level. Thank you.
Representative Larson.
Thank you, Mr. Chairman. I rise in support of the amendment. We stood here and talked about being equitable and about being fair to the people, but only when we want to be fair, right? And so I don't think, it doesn't matter if it's only 3% of the people. I think you have to treat them all the same. And if you're going to give this type of tax relief, I think you've got to develop a formula that is equitable across the state, whether you're living on the eastern part of the state where the property values aren't as high, or in the county where the mountains are high and borders the state to the west of us. Boy, that really has a bitter taste in this approach that we're now looking over the hood and trying to avoid the weeds in the bar ditch here a little bit. I think we got to step back and rethink this a little bit. Now, it may cost us, but that's, we've been having that argument for a long time. But if you're going to do it fair. I encourage support of this amendment.
Representative Wiley.
Thank you, Mr. Chairman. We're talking about equity and talking about, raising the cap. Wouldn't it be more equitable to use a median cost? And I did some keyboard calculation over there, right, really quick, while everybody's debating on the floor with all this time that we have. And I come up with like $340,000 and change. So if we are going to talk about equity, maybe we should lower it down to something like that. And then also it would be less impactful to budgets. Thank you.
Representative Worf.
Thank you, Mr. Chairman. I rise in opposition to this. As was mentioned, this was brought up and discussed by the committee, and it was defeated. It was defeated because it does say that it sets the basis of $1 million. So it's everybody up to $1 million gets the credit, gets the ability to apply for the deduction. Those that have homes that are worth more than $1 million get the full benefit of this tax deduction. Those who have homes that are only worth $100,000 are only getting 10% of what they're getting. So I look at it, to me, I think it is fair and equitable. It's the first $1 million. If your property is not valued at more than $1 million, you don't get more money back. You get the value of you get the return from your taxes. It is as fair and equitable as we can make it. I don't think we can give it to everybody, but this does make it fair. Everybody gets the same amount of a deduction. Thank you.
Representative Ottman.
Thank you, Mr. Speaker. And everyone, please excuse me for my noise a little while ago. I would just like to say, last year we debated property tax because it is important. And with the rise in property taxes that we've seen over the last few years, lots of people are at risk. But what I am in support of the bill. As far as the amendment goes, I would just like to ask those of us that were here last year we debated and debated, and one of the things I remember very clearly is when we said to all taxpayers, we were told that there was a portion of people in the state who were so wealthy that they really did not need to receive that exemption and that relief. And so here we are saying now it's not equitable, and it just confuses me. Is that being used? What we're talking about is equality, and to use things back and forth is just not right. We are tasked with keeping people in their homes, okay? The people that are paying these outrageous amounts are in their homes. The millionaires and billionaires and those people that just own properties part of the time, they're handling things relatively well, even though I agree that they pay a lot more because their properties are worth more. But this is a good bill to hit our people in our counties now, because their property taxes are coming due. And if they do not pay them, they will lose their homes. So I would just say no on this. Thank you.
Representative Larson.
So last year I received a call from one of my constituents whose mother lives in the town that the good preparer of this amendment lives in. Her family settled that part of the world. A lot of times in calendars, you see this old barn out in the middle of a pasture with the Tetons at the back. That's their family. She's 90 plus years old, never lived anyplace else. Her husband died when she was certainly not old, and supported herself through working at hotels and whatnot, and restaurants. So now she lives in a house about the same square footage as mine in the center part of the state. My house is valued at $250,000. Hers in that community is valued at $1.4 million. Lived in it, has never lived in another house in her married life. So I get 50%, right, up to the first million. So I'm getting 125. She's still at 900,000. I don't think that's fair. I don't think that's equitable. And no, all the people that live there are so wealthy that they don't need any type of help. So I just appreciate what we're trying to do here, but we really should take a step back and say, is it being focused in an equitable manner? And I think that this amendment goes a long way to do that.
Representative Storr.
Thank you, Mr. Chairman. Thank you for the discussion. I just think I would point out that I think there is still a live debate in the state between what Article 15, Section 11 requires and what Article 1512 allows. There is a word in there that says such other property as the legislature. It doesn't say other property as the legislature may be by general law provide. There's a real question about what the Constitution says we can give exemptions for. And I think some of that's, we've seen that challenged over the years. So I would ask that you please consider the constituents in the northwest part of the state that really are the ones that have seen their pocketbooks impacted the most, and support this amendment. Thank you.
Representative Locke.
I just ask that you resist this amendment. Let's get some relief onto the, Wyoming people's kitchen tables. That's what this is about. Let's do it as broad as we can. let's make this happen for the people in Wyoming.
Question having been called, all those in favor of Committee of the Whole Amendment number 1, please say aye. All those opposed, say no. No. Committee of the Whole Amendment number 1 has failed. We are back on the bill. Representative Locke. Representative Byron.
Thank you, Mr. Chairman. And to the good chairman in revenue, I was thinking back to our 2 years together in the basement, learning about all of these things and reflecting the stained glass and the light. And I remember a bill that we got through, and I just am trying to get the details right and maybe get some clarity where we went from 25 to 50 and how we've gone from 2 million to 1 million. And I'm happy to bring a later amendment to maybe up that number from 1 to 2 million, but I just was trying to, without opportunity to go see your wonderful committee, just trying to figure out why we did what we did when we had really good legislation that passed through both bodies last session.
Representative Yin.
Mr. Chairman, thank you. So to the sponsor of the bill, I'm curious on whether you had any thoughts on what it would be like for second homeowners and why would we give a 50% exemption to someone who lives in California and has a house that they spend 1 month of the year in? Does that make sense for us? And would you be open to amendments changing that? And had you thought about it when you drafted the bill? Thank you, Mr. Chairman.
Representative Washington.
Thank you, Mr. Chairman. My concern isn't with the relief, but the backfill issue. I do worry that without a backfill, our local governments are going to be in a bind. But at the same time, those local governments are the ones that have benefited from the assessed valuation increases in their communities, not the state of Wyoming. And so by doing the backfill, it sounds to me like we're taking money from the mineral industry and giving it to the cities, counties, school districts, special districts, college districts, et cetera, to backfill for the reduction in property tax assessed on the people who live in those communities. So I'd like to hear more about how the committee came up with the idea of only backfilling 50%, where'd that number come from, and a sense of if this initiative passes and we set a precedent of backfilling, then this backfill is probably going to go on indefinitely into the future is my big concern. So just what are the committee's thoughts on those things?
Representative Harshman.
Thank you, Mr. Chairman. Just a question. The corrected fiscal note has revenue decreases of $395 million over 2 years. And so a couple questions in. So my first question, is it clear in the bill that this half of the backfill, because we're going to backfill half of the amount that we're exempting with the $225 million appropriation, $125 million general fund, $100 million through the legislative stabilization reserve account. Is that going to be half and half each year on the backfill, or is it just going to be that 1 year? I just want to make sure where that was clear in the bill. And then I was just wondering, Mr. Chairman, that if the Revenue Committee had some information on how this really affects our hometowns and our counties. I mean, we know that 70% of that's going to be schools, so it's going to increase school expenditure. The state is going to take care of schools, so we're going to have more entitlement payments to school districts. But I guess my thing is like, how does this affect our community colleges, special districts, fire, sewer, senior citizen districts, weed and pest, all those districts? And then another question really about bond payments. Some local entities have bonds that they're making payments on with property taxes, and how that will the backfill. All these things, it's a complicated deal. I'm just wondering how that's, but really I would like to see information for us so I can look at county number 1 on your license plate and say, oh, it's a $5 million reduction. Because that's what it's going to be in my county. And I think it's 6 or 7 in county number 2, just doing Little League math on my own at my desk. But anyway, I think it'd be really helpful for all of us before we pass this or vote on this on third reading. What does it actually do to our locals and our hometown? So thank you, Mr. Chairman.
Representative Larson.
Thank you, Mr. Chairman, and maybe while we're in the requesting mode of the bringer, the Chairman of Revenue, my assessor is looking for clarity and doesn't feel that it is provided. You added a little snippet of that when you said that if they qualify, if this is provided, then they couldn't qualify for the long-term homeowners insurance. But what about the veterans rebate program? What about the other homeowners program? And I think there's 2 or 3 other amendments out there we passed. We talked about the 4%, but there's a couple of other out there. So can they still qualify for multiple programs? And so if you could help us understand that and how that's going to impact my county would be very helpful. The other concern that I have as we get into this backfilling mode, as property tax comes back to the locals and the towns, we vote. In my county, we vote on what we want to have property tax assessments for, whether it be a cemetery district, hospital district, college, all of those things. When you backfill with state general fund dollars, you don't get any say in how you didn't get to vote on the taxes that I passed in Fremont County, nor did I get to vote on the ones that you passed in Laramie County. So we get in this nice habit of backfilling. We're crazy not to pass every tax assessment we can because the state's going to backfill it, right? Then the other problem when we get talking about the backfilling is our mineral industries that the good chairman of Judiciary noted. They pay their property tax on 100% valuation of the mineral. Then they're paying property tax on the real property. So they're making all of this infusion. Then they take their severance tax and all of that we receive in our general fund, and they say, we pay that for the general services of state government that we benefit from. But now you're going to take that tax money that we're paying to pay the citizens' property tax. And they're crying foul that there's not that they're carrying a bigger burden than they really should be when their tax dollars were intended to go another place. So these are just some things I think that we need to consider. We have addressed some things. I think we talked about Amendment A, we talked about the 4%. And it may be worth us just kind of sitting back and looking, because from the reports we got from the state, the director from Department of Revenue is that we're seeing impacts from resulting from the things that we took. Maybe we ought to let the dust settle a little bit before we do this and impact the rest of our things. So appreciate the conversation, and Mr. Chairman, I'd appreciate if we could get that information. That'd be very helpful.
Representative Bear.
Thank you, Mr. Chairman. I want to address that last comment of letting the dust settle. We can no longer dither and delay. This body is under a great deal of pressure from our own constituents because we have dithered and delayed. This issue, this bill is addressing an issue that started happening in 2019 and has continued for a few years. And every one of those entities that we're talking about helping with the backfill received additional revenues. And yes, we locally can decide if we want to tax ourselves for a particular additional entity in our communities, but what we can't do is we can't vote on what our assessment's going to be. And that's where this problem came from. The assessments got out of hand. And we addressed somewhat that issue last year. We were late, I would say, by about 2 years when we finally did that with the 4% cap. But what that 4% cap did is it permanently put in place where we're at. We can only go 4% more from that. We're not going back and addressing all the additional taxes that the taxpayers paid from 2019, 2020, 21, 22, and 23. This bill fixes that. Obviously, there's something coming on the next ballot in 2026 that may impact all of this. We don't know. But to the previous speaker's comment about our other industries, I agree. I would like to give them a tax break, and guess what? We have a bill for that coming as well. Someone from my community, one of the representatives from my community is bringing a great bill to deal with that. But what did this body do when we had large S from all these tax increases? We put it in state savings and did not give it back to the people. So last year we put $700 million into savings. The year before that was over $2 million. We've put almost $3 billion, I'm sorry, in the last few years into savings, which is great. But we failed to take care of the taxpayers and the pressure that they were under. If the state's savings account is going to grow, then I would hope that our constituents' savings accounts would grow as well. And until that happens, I'm going to continue fighting for this kind of tax relief for our constituents. On and for the bill.
Representative Davis.
Thank you, Mr. Chairman. We had a brief meeting with our county fathers before we come down here, and they evidently are not in favor of any additional relief to the property owners. They are still trying to figure out where they are from the last tax relief that we put out there. They're also suffering from, what we've talked about on many bills, is the aging infrastructure of our counties, our municipalities, our utilities, everything like that. So coincidentally, the perfect storm seems to be coming to play here. So unless we can get some real dollar values that we can take back to our county fathers, it's hard for us, or for me, to vote in favor of additional tax relief. Now, if we have some way to restructure our taxes, maybe that would be a better way to go. But I caution that we need to slow down, see what this has done, and how the rest of the state is going to react. I mean, we've been on a lot of scrutiny on how our infrastructure, from the dams up the river and over here and that, I mean, there's a lot of dollars out there that we're worried about. So anyway, I would like to see some real hard numbers where our counties would sit.
Representative Harshman.
Thank you, Mr. Chairman. I just want to kind of get everybody, and I just want the good chairman from the Campbell from County 17, I just think I want to address this savings piece, because I think let's first talk about the assessments have never changed on residential property. They're 9.5%. They've been that way for decades, since I was a little kid growing up in this state. Valuations went through the roof. Response to the pandemic, a lot of people moved here, paid cash for houses, and all of our assessments went up. And those are, of course, constitutional. They have to be fair and equal. And we have a great assessment system in our state. It's a statewide CAMA system. It's the envy of a lot of states, but it went up. So we've responded, right? But that money doesn't come to the state. Those are local taxes. Property taxes are not state taxes. They don't go to the general fund. And so the money that we were able to save, number one, it came from the federal government with COVID money. And they allowed us to substitute federal dollars for state dollars for corrections. We ran our prisons on COVID dollars for a couple years. We ran Workforce Services, Department of Family Services, and much of the Department of Health. And so instead of growing government, previous legislators then took that offset general fund money, which also took off because there was a war in Southern Europe. And it drove natural gas prices through the roof, and we had a little boom. Even coal picked up because natural gas got so state coffers grew. But we didn't grow government. And we took that mineral money and that federal money that we swapped, and we put it in long-term savings and invested it for our people for the future. So I just want to make clear to the public who's watching on the YouTube, the increases in our state savings did not come from anybody's property taxes. Didn't happen. It came from COVID money. It came from a war in Southern Europe that affected natural gas dramatically. And it came because we had conservative legislators who didn't grow government and save for the future. So I just want to set that deal straight. But as we work this bill, there's a lot of details to this. So when I read on page 4, again, Mr. Chairman, I just want to make sure, because it almost reads like the whole payout's going the first year and then there's nothing the second year. I just want to make sure we're clear on that, if you can answer that. So thank you for indulgence on that little history the last 5-6 years since COVID. But thank you, Mr. Chairman.
Representative Lee.
Thank you, Chairman. I just want to make a few points about this piece of legislation. Property taxes, when you go to your county treasurer, you can ask them for an itemized statement on your address, or you can ask for the county as a whole, and they can give you the exact dollar amounts, penny for penny, where property taxes go. I have done this. I've had the opportunity to look at my personal tax bill and see where my money's going. Less than 50% of it goes to my county. The rest of it goes to the school foundation program in my local school district. And I'll tell you, I feel like I'm getting robbed in education as a homeschool mom. I will also say that I am in favor of acquisition value. I know this bill isn't talking about that, but when you're talking about a continued valuation increase, these people are paying unrealized gains on their taxes. We need to make sure that they are taking the opportunity to keep this money in their pockets because they aren't selling their homes. These tax dollars need to pay for our county services, a little bit to education, and then make sure that they stay in their homes. This bill gives them that opportunity. I want to say that this gives the people what they asked for with the ballot initiative. There's been a lot of talk about tax reform. Let's give them that in the interim, but right now they need this relief. I ask for a favorable vote on this piece of legislation. Thank you.
Representative Nicholas.
Thank you, Mr. Chairman. Just a couple of things that I think we need to think about as we do this. There are multiple property tax bills and there's lots of dollars and ideas floating out there. And we need to kind of put them all on a chart and figure out which ones are which and make sure that we don't have multiple property tax bills that we can't afford, and that we do the right ones and do the right ones as fair as we can. So it's interesting to note, by the way, that there were certain counties in Wyoming that didn't have inflation, high property tax increases. Take Sweetwater County, I think I can say that. They had less than 3 to 4% increases annually since 2019. So the idea of who you give the property tax to in just a blanket manner is probably not quite equitable and fair, and we could probably figure out a formula to figure that out. But I think you have to take that kind of thing into consideration. And then where the money comes from. Right now, if you take all the bills we've got lined up in the coffers, it's $495,260,974 of general fund dollars, just in bills that are currently on the floor of this House and on the other body. Roughly $500 million of general fund dollars that these two bodies wanted to expend in the next 2 years. And so we have to take that into consideration when we talk about relief and how we're going to pay for it. And I think we all know that there's no such thing as a 2-year property tax relief. It's a fiction. So whatever relief we recreate is going to continue, either through the amendment that just passed on property tax relief that'll be on the ballot, or from this body. We're not going to say we're going to give you 2 years of exemption and then all of a sudden we're going to do something different. So the amount that we pay and we decide to return to our constituents needs to be an amount that we can afford and that doesn't deplete our coffers and savings and doesn't take away from our general fund dollars, which we rely on for Department of Health, Family and Social Services, all those other things that we do, payments to our locals. Every one of those are going to be affected by this sooner or later if we're working with right now, in a big numbers, $400 million 2-year tax relief. So you have to line all this up and figure it out, and you can't take it one property tax bill at a time. And you have to have, I believe, the perspective that whatever we do is going to be permanent in one way or the other.
Representative Worf.
Thank you, Mr. Chairman. I have to rise, I guess, and speak against the prior speaker. That is not what this bill does. This bill buys us 2 years. And I can tell you it's the intent of the Revenue Committee, of which I serve. What we believe is we need to buy the committee time so we can get our hands around all this. We all agree there's been all these piecemeal cuts everywhere. We need to get our hands wrapped around it. We need to reassess the entire tax structure in this state and reassess it. 60% of property tax is being consumed for education. I'm not so sure that that's what any of us feel should be the right number. Those are things that need to be assessed. They need to be reevaluated. And I do think we got to do something. I mean, I can tell you everybody that I've talked to that campaigned this year had the same thing. It is wrong to have people in this state taxed out of their home. And I had numerous people tell me that. And I can tell you it's real. We have to do something for the people that live here. And yeah, I understand it was pointed out that the property tax isn't what, it was all spent. It's not like the property tax was diverted into state savings. And I agree, the majority of the people do not understand our current tax structure and they don't understand how they're being taxed, where their taxes are going. That's one of the reasons why I think we need to reassess the entire tax structure in this state and make sure that it's right. I believe that there's been some errors. I believe we were told by some other entities, some things that we had to do as a legislative body to continue providing funding that I don't think is appropriate. Nobody's challenged that. But I think we need to, as a body, we need to get our hands wrapped around all the numerous changes that we're talking about. That's what this bill does. It buys us 2 more years, and it is in the bill. It's 2 years. And I can tell you, I have no intention of making this permanent. I don't think anybody does. It's very specific. This is a limited 2-year relief to our taxpayers. And I do think it needs to be done. So I urge the support of this. I ask you to support House Bill 169. Thank you.
Representative Johnson.
Mr. Speaker, thank you. Yesterday I brought up rules that we would find money if we spent money, and I called it magic monetary theory. And the body said, "Don't worry about it. We can spend as much as we want." And now today you're saying we can't spend it on this, but yesterday it was okay. We could spend on anything we want. We didn't have to backfill it. We didn't have to find anything. Just spend, spend, spend. And that's why I think we need to support this bill. Thank you.
Representative Storr.
Thank you, Mr. Chairman. All of our counties are coming to town this week, and I really do hope all of us will take the time to visit with our commissioners, visit with our town council people, and also recognize that cutting property tax in this way really does impact so much more than we realize. And one example we heard from, that I got some more information on more recently, is our critical care hospitals. Those are our small hospitals. Those are hospitals in your communities. Most of them are working and operating on a negative operating budget now. They are barely holding on. And this bill would likely take out about $600,000 to $2 million for those hospitals in your communities. That means they'll be cutting things like behavioral health, obstetrics, and other specialty services. You may still have an emergency room, but you may not have much else. It's how they maintain their facilities as well. So you still have those services. I think at the end of the day, we really want to think about how do we build prosperous communities across this state? And I think a lot of our communities are suffering because they aren't able to create a community where people do and want to live, especially young people that keep our communities so vibrant, that keep our schools in place. So I do hope you'll visit with your local communities over the next few days and talk about these different bills and really try to figure out what is the best for your community moving forward and the state. Thank you.
Chairman Locke.
I want to throw in just a few things. I know there's more speakers, but I wanted to just throw in a few things and answer a few questions. So for the representative from my county, I did want to let him know the intent of the bill was to do a 50% first year and then a 50% second year was the intent. If the language does not make that clear and we need to, I welcome that discussion. Absolutely. For the speaker who discussed the fact that how do these all play together? Well, first of all, let me go back and say, absolutely, we're trying to look at all of the exemptions and how do the current exemptions that are in place play together. That's obviously a very critical issue. That's one of the things the amendment tried to do. It said, if you request a long-term homeowner, this exemption will not apply. We've already worked with the department to make sure we're trying to put the right rules in place to make sure those things are covered. So we definitely are trying to make sure that does happen. Now, the vet exemption and some of those things, yes, we've looked at all of those. We've looked at the refund. We've looked at the veterans exemption and all of those to try to make sure those flow together. So we're working with the department, make sure we've got the right pieces in place. And then the backfill concerns, it's absolutely right. Somebody had mentioned that there's backfill with People's Initiative. In fact, there's not backfill with the People's Initiative. So if they vote that in, there is no backfill for that. And so one part of this process, I understand that local communities are affected. We're trying to look for the best way to approach this, not cut the legs out from underneath government, but I will say this is focused on the people with no question about it. We're talking about people who we have not given that relief that they've been asking for years. And so most definitely it is focused there. One other person I did want to respond to, and I'll try to do this quickly, he had asked about why not the owner occupied or something like that. That has been a question that's been asked for the 3 years I've been here, to be honest with you. And the truth is, we can't even use those options because the current system the department has in place won't support it. So that's why we didn't consider that. I at least wanted to let you guys know answers to a few of these questions, and I'll try to get off the mic fast. Thank you.
Representative Williams.
Thank you, Mr. Chairman. I'd like to offer a little different perspective than what we've been hearing as representative for the smallest county in the state. 2024 tax collections for said county were $195,631 total. And this bill as written would yield a reduction in tax revenue to said county of $48,908. And that exceeds the entire increase in property taxes for the last 6 years in that county. And I'd just like for us all to consider if that's really the intent of our bill here, and maybe you can help me with an amendment in the next couple readings that can address that situation. Thank you.
Representative Campbell.
Thank you, Mr. Chairman. Want to absolutely appreciate the intent of this. I get it, I do. And one of the things, I think a concern I have is as I was out knocking on doors, like most of us, there was a lot of concern about property taxes and how much we're paying in property taxes and the reduction in property taxes. And so then I would ask the question, do you know where that money goes? And do you know where funding goes? And so most that really want property taxes, most of the conversations I had didn't understand the implications and the impact that would have. So once I explained, here's the damage, here's the hurt to our city, here's the hurt to our county, here's the hurt to, they're like, oh, well, okay, then that doesn't sound like a great idea. So hopefully this discussion will serve as that education part of it. My question, I guess, to the bringer is some clarity for me, because we talk about on page 4, oh, no, that's not where it is. Wherever the reference, okay, so on page 3, line 11, that 50%, right? There will be a backfill reimbursement of 50% of the loss. Then on page 4, starting on line 22, the state treasurer, out of funds appropriated for that purpose, shall reimburse each county treasurer for the amount of taxes which would have been collected if the property was not exempt. The county treasurer shall distribute the revenue to each governmental entity in the actual amount of taxes lost due to the exemption. So I'm not sure, there's either we're reimbursing for the exact amount of what was lost or we're reimbursing for 50% of what was lost. I just want to make sure I'm clear so I can answer those questions. Thank you, sir.
Representative Lean.
Thank you, Mr. Chair. I just want the body to know that as the Revenue Committee has convened, we have identified that some counties have 3 years of revenue. Some counties have 100 operating days. We know that there are challenges within everything that we are doing within revenue. This has been given every ounce of thought that it requires. I know that we have put together the best work possible. We're here to offer the debate so that maybe the body as a whole can offer a few amendments or no amendments. Maybe it's the best work possible, but this is the chance for the team to come together, work for the people, and give them what they desire, the 50% ballot initiative. Thank you.
Chairman Locke.
Thank you, Mr. Chairman. Just to answer the question that was brought up before from the person from my county, yes, right now the way it works is the objective is to have the treasurer backfill up to the amount, but it's limited, so it's up to 50%. So it's 50% of the assessed the amount of reduction. So hopefully that's clear, or maybe I stumbled over that again, but hopefully that's fairly clear. So,
Representative Clauston.
Thank you, Chairman. I just want to give a little perspective on this. There are 10 states that paid less in property taxes than Wyoming, but all 10 of those states have a state income tax. The lowest being Louisiana at 4.25%. Hawaii goes up to 11% on income tax. So there's ways to get taxes, right? Income tax and property tax. Wyoming, we're very, very it's a great benefit to live here. We pay some of the lowest taxes in the nation. So when you hear there's other states that have less property taxes than Wyoming, that's true, but they make it up in income tax. Thank you.
Further discussion. Question being called. All those in favor of Chairman Locke's motion that when the Committee of the Whole rises to report, do so with recommendation that House Bill 169 do pass, please say aye. Aye. All opposed, no. No. House Bill 169 has passed the Committee of the Whole. The next bill for our consideration is House Bill 116. The reading clerk will please read the bill.
House Bill 116, sponsored by Representative Ottman. Driver's licenses, unauthorized alien restrictions. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred House Bill 116, driver's licenses, unauthorized alien restrictions. Respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Brown, Heft, Johnson, Knapp, Locke, Lucas, Webb, Weber. Noes, Representative Yen. Representative Knapp, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Knapp?
Mr. Chairman, thank you. I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill number 116 do pass. And with that, I will give the explanation of the bill over to the representative who does a great job raising her hand to vote.
Representative Ottman.
Thank you, Mr. Chairman. Good evening, body. I'd like to present to you House Bill 116. This bill is titled Driver's License Unauthorized Alien Restrictions. So what I'd like to do is just go down through the bill. It's only like 4 pages. And, okay. It's an act relating to driver's licenses. Section 1 is created to read unauthorized aliens, invalid out-of-state driver's licenses, and non-resident operating privileges. Okay, as we go over on to page 2, any driver's license or non-resident operating privilege, a privileged document issued by a jurisdiction outside Wyoming to an unauthorized alien or any driver's license or non-resident operating privilege document that is substantially similar to a driver's license. And then down on line 7, it says that did not provide proof. In Wyoming, and I'm just going to add this right now, in Wyoming, what we require is a state certified birth certificate and or a passport. For immigrants, they have to have documents. We have proof of social security number, 2 documents that could either be a vehicle registration or a cell phone bill with the address on them. On there, the document must have the name and the physical address, not handwritten, proof of a name change. So if you're married or for some other reason change your name, that needs to be documented. And that is all found on the DOT website. So as we go through there, that is what this is requiring, that anyone driving in the state of Wyoming must have fulfilled the same exact requirements that any of us have provided. Let me see here. Okay. Oh, I probably should get, what I'd like to do is just to go along with that. If you have recently moved to Wyoming, you will need to apply for a Wyoming driver's license in person. These are according to the bureau that does the transportation rules. So you have 1 year from the time you establish residency to be issued a Wyoming driver's license. If the license you currently hold is issued by one of the following states, and then it names some states which that's controversial whether I should read that. Commercial driver's license, you must apply for a Wyoming license once you have established residency in Wyoming. If your privilege to drive is withdrawn due to suspension, cancellation, denial, revocation, or if you are disqualified in Wyoming or any other state, you will not be issued a Wyoming driver's license until you have met all the requirements for reinstatement of your driving privileges. If you are unsure of your driving privilege status, you can go to the office. You can only do that in person, and you're required to show identification at that time. So as we go down through there now on page Section B, as used in this section, unauthorized alien means a person who is not a United States citizen and is not lawfully admitted in the United States. And as I was just reading, the qualifications already say that. So for that, you have to have it. Persons exempted. The following persons are exempt from the licensing requirement under this act. So there are some things that we need to realize. An employee of the United States government while operating a motor vehicle owned or leased to the United States government and being operated on official business, unless the employee is required by the United States government or any agency to have a state driver's license. And the driver's license is not invalid under 317143, which is what this bill creates. Roman numeral 2, a non-resident who has in his immediate possession a valid license issued to him by the licensing authority in his place of residence, if the non-resident's license is not invalid under 317143. So if they have a license from a place elsewhere that conforms into the requirements that we have here in Wyoming, they're fine. A non-resident on active duty issued by his state of residence and non-resident spouse or dependent son or daughter who has a valid license by the person's state of residence, if the non-resident's license is not invalid by 317143. So if it meets the requirements here in Wyoming, they're fine. A full-time student, Part 5, at the university here in this state, a community college in this state, a school licensed in this state, let me see, parochial, religious school, post-secondary, if their license is not invalid according to this statute, which is also the requirements by this state already in our rules and in our statutes. 317134, driving while license is canceled, suspended, invalid, or revoked. I just read that to you a minute ago. No person shall drive a motor vehicle on any public highway in this state at a time when his driver's license from this or any jurisdiction or non-resident operating privileges are canceled, suspended, deemed invalid, or revoked under this act or any law. If so, it's a misdemeanor punishable by a fine of not more than $750, by imprisonment for not more than 6 months. That penalty is already in effect according to our statutes for drivers in the state of Wyoming. So that's just to do the same thing. Section 3, the Department of Transportation shall promulgate any rules necessary to implement this act. And then, except as otherwise provided, it will be effective July 2025. It is time for states like ours to affirmatively recognize and codify under our Wyoming law that driver's license documents issued to illegal aliens are not recognized as valid credentials under Wyoming law. Again, this bill will ensure that Wyoming does not recognize and deems invalid any driver's license issued to an illegal alien by another state. There are now 19 states and an organization that a lot of you may go to for some training have recognized 19 states that have already put into their law that it is legal for them to drive without valid, what we would deem as valid driver's licenses in our state. In Wyoming, we use our driver's licenses as a form of identification for many, many things. It's important to us. And while it won't cause roundup of people, it will help law enforcement to identify when there is someone that doesn't have the proper identification, and things can be taken care of there. I would stand for any questions.
Representative Campbell.
Thank you, Mr. Chairman. Not a question, more an observation and perhaps suggestion. I have two family members that work for our department that oversees Wyoming's transportation. And it has been drilled into my head that it is a driver license. If it's plural, it's driver licenses, but anytime you add an apostrophe S, it changes the intent because it now is an individual's license that they have in their possession. It is a driver license, which may affect the intent of your bill, the bringer's bill, and other bills where we reference the driver license. There is no apostrophe S. Thank you.
Chairman Brown.
Thank you, Mr. Chairman. Ladies and gentlemen, just a little over a week ago, we put our hand up, we swore an oath to the Constitution, not only of this state, but the United States. Article 4, Section 1 of the United States Constitution says this bill is blatantly unconstitutional. Blatantly. Let me read that to you. Full faith and credit shall be given to each state to the public acts, bills, laws, records, and judicial proceedings of every other state. Congress may, by general laws, prescribe the manner in which other such acts, records, and proceedings shall be proved and effect thereof. Now, I am not a constitutional scholar, I will admit that, and I'm seeing somebody shake their head at me. But I'd like somebody to provide me the verification that we are not in fact violating the United States Constitution by saying we are not going to allow somebody else to drive into our state without proper verification. And then I would also ask, how is this implemented? How do we know what other states do? Or how is that police officer going to know what I believe it was 11 other states are going to do when they're asking for those driver's licenses? One of those is that big long state just out to the west and has a coast on it. And I know, I don't like this. I don't like that they can drive through here, and I've heard horror stories. I lived in state down to our south where many of these individuals have caused accidents and take off fleeing, all sorts of nasty stuff. But my oath to the Constitution is far greater than a couple of anecdotal stories. If I can get some proof that we are not violating the United States Constitution by making this bill make us feel good when we go home to our constituents, you bet, I'll vote for it. But right now, this seems like we're just offering up red meat. We're seeing a whole bunch of bills come out here that make us feel really good about what we're trying to say. But this one is really, really making me uncomfortable and really making me feel like we're violating the Constitution.
Mr. Chairman, point of order.
What's your point?
Mr. Chairman, thank you. So in Mason section 124, number 3, personalities are not permitted in debate. It's not allowable to impugn the motives of any member or committee that brings a bill. And so I just ask that members speak, specifically about the content of the bill and not impugn other members or committees that have sponsored the bill.
Point received.
Mr. Chairman, I'm just going to go on the record here. I never impugned a single person. I stated my opinion, and that is fully allowed.
Representative Conley.
Thank you, Mr. Chairman. I understand the intent here, but I have a question, and maybe the bringer can answer it for me. How does this affect all of our truck drivers? we've got truck drivers coming through from all over the country, and a lot of the truck drivers are maybe of a different state. They get their license, maybe okay in another state for them to have that license, but according to this, if I understand it right, it wouldn't be legal for them to come through Wyoming on I-80. Am I misunderstanding something? Thank you.
Representative Yin.
Mr. Chairman, thank you. So members, in committee, we did have one of the folks that patrol our highways testify and what the implementation and enforcement would look like and what it looks like when we receive IDs from other states when they pull somebody over. When they pull somebody over and they have an ID, they run the ID through their system. The system says valid or invalid. It doesn't say citizen, non-citizen. So the information that they actually get back from those records is whether it's a valid ID. And so to enforce this, the trooper would then have to say, okay, it's a type of ID that I suppose isn't one that a citizen could have that's issued by another state. So I'm going to have to run it through another system that goes to the federal government that says, is that person under record by the enforcement mechanism in the federal government that enforces immigration and customs. So if that happens, it takes 15 to 30 minutes to get a return back from that system, according to the testimony we were given. So the question is, will every trooper to enforce this run every one of those IDs and spend 15 to 30 minutes waiting specifically for their return? Or will they likely just never run it at all and then the bill just doesn't get enforced? So I think the bill is kind of unenforceable, let alone unconstitutional, but you know, maybe it feels good.
Representative Ottman.
Thank you, Mr. Chairman. Let me address just a couple of this. As far as business people running through, in order to drive across state lines, you would have to have a valid driver's license. So therefore, you would have to meet the criteria that we already have set forth with the department that governs the transportation. So if they do not have a valid license, they do not have a valid license. This also is only checking for illegal people. This is not checking every driver in the state of Wyoming. And as far as the full faith and credit clause, it requires all states to recognize valid laws and the judgments of other states. So giving credentials to illegal immigrants is an invalid act. So if they're not a citizen, they are not driving with valid credentials, period. This is not to grant a driver's license. This is not to have people take a test or their eye test or to report in person. This is specifically saying that there are restrictions for unauthorized alien people. The first criteria for our license is to show proof of citizenship. So there you go. That's what it's for.
Representative Jarvis.
Thank you, Chairman. So Wyoming is a huge tourism state and industry. I'm a little confused by that because how does that impact when Canadians are driving through our state and non-US citizens are here to vacation and come through and enjoy what we have to offer and then leave? Like, is that covered in here or am I missing it?
Mr. Chairman, they would have a, no, I'm sorry.
Representative Brown.
Thank you, Mr. Chairman. So I just heard that the statement was made, this is only for illegal aliens. I'm trying to put this into my brain that if I am speeding down I-80 and I'm doing 95 in an 80-mile-an-hour zone, and a highway patrolman nabs me, pulls out, whips over, pulls me over, comes up to my door. How in the living world does he know whether or not I am legal or illegal?
Mr. Chairman? Oh, Mr. Speaker. Okay, Mr. Speaker. Chairman?
Representative Ottman.
Mr. Chairman, thank you, I apologize. To the last question, I imagine you would show identification on your way to jail.
Representative Ian.
So, Mr. Chairman, thank you. Members, again, if you come into the state with a Mexico ID or a Canada ID driver's license, a Canada driver license, or or a Mexico, I can't say those countries. The countries to the north of us, the countries to the south of us, or any other country outside the one that we're in, with one of their licenses, the trooper doesn't have a way to verify whether it's a valid license because it's not issued by one of our states. So they, at the most, they usually just accept it. At the worst, they can ping Interpol, which is going to take longer than 15 minutes, or ICE again. Sorry, oh my goodness. Sorry, it's getting late, my apologies. They can either ping the police force that polices international law, or they can, to see if they're a fugitive in that system, or they can ping, again, the federal enforcement mechanism, again, which takes 15 to 30 minutes. The license does not tell you whether they are illegal or undocumented or not allowed to be here, right? Or overstaying their visa. The license doesn't say that. So again, the only way to enforce it is the trooper has to make a thought request to the system, which is going to take 15 to 30 minutes. So either they're going to do that for all the licenses, or they're not going to enforce it.
Body, I know it's getting late and dragging on, but we really need to maintain the decorum in here. Let's keep our debate tight. Let's keep it on the issues and continue on. So thank you, Chairman Washit.
Thank you, Mr. Chairman. Just want to verify, I don't remember reading in the bill. Does this specify that this has to be a secondary offense? Or can an officer who sees someone who might somehow look to be a worthy suspect of this offense and then stop them only for that? Or do they have to get the traffic violation first and then verify the driver's license?
Representative Ottman.
Thank you, Mr. Chairman. What this covers here under 317134 is, and it says down here, if no person shall drive a motor vehicle on any public highway in this state at a time when his driver's license from this or any other jurisdiction or non-resident operating under this act, or any non-resident operating privileges are canceled, suspended, deemed invalid, or revoked under this act or any other law, except as provided in subsection C of this section. A person convicted of violating this section is guilty of a misdemeanor punishable by a fine of not more than $750 by imprisonment for not more than 6 months. And that is current statute. That is in the laws, and that is the fine that is implemented currently. So this is just reiterating that. And that was put in 2021. Excuse me, Mr. Speaker.
Excuse me. Representative Lucas.
Thank you, Mr. Chairman. I had done some research while I was in committee hearing this bill, and there are 19 states, and including Puerto Rico, that issue driver's licenses to illegals. And of those 19, 12 indicate on the face of the driver's license whether it is a permit for driving only, which is how they label the driver's license is issued to folks who don't qualify for one. Thank you.
Representative Pendergraph.
Thank you, Mr. Chairman. Wonderful evening. I wanted to mention that the full faith and credit clause applies to the valid acts of other states, and recognizing licenses for illegal immigrants is not a valid act. We are a nation of laws, starting with that very Constitution. And when someone comes here and their very first act is to ignore our immigration laws, they have no rights, they have no validity, and we should not honor them with any of the rights of citizenship. Thank you.
Representative Lean.
Thank you, Mr. Chair. I have a question of clarity for the bringer of the bill. Say we have some immigrants that are here, but their visas have expired and they are currently working on restoring their visa status for either an extension or a citizenship. But given the challenges of our immigration policy currently federally, what happens to those individuals that are stuck with an expired visa but are actively pursuing either citizenship or a new visa?
Mr. Chairman?
Representative Ottman.
Just to answer that, whatever laws apply to receiving a valid driver's license would apply to those people. So their visas or whatever that's in state right now would apply for that.
Representative Kelly.
Thank you, Mr. Chairman. I'd like to just get some clarification. A previous speaker had spoken, had asked a question. I'm not sure if it was answered. I think the concern is, what safeguards are there against racial profiling if this gets instituted?
Representative Chestic.
Thanks, Mr. Chairman. In response to a previous question, I don't believe it is illegal for a state to decide to give driver's licenses for driver's purposes only to anybody they want to. It's their choice. But whether that's, I believe that's true, but even if it's not true, how is the trooper going to know whether the license was valid issued or not? There's no way of knowing that. So putting this requirement on the trooper who is making the stop, it's impossible to enforce. So I'm against this bill.
Representative Ottman.
Thank you, Mr. Chairman. What I would say is that a person wouldn't be approached by an officer unless there was reason to be approached. I mean, if they're driving down the road and everything's fine, I don't know why anybody would be pulled over. This is just to say that we do not issue driver's license to illegal aliens. This is not to make judgment calls. This is just in the issuance of a valid driver's license in Wyoming.
Further discussion? Question being called. Oh, excuse me, Representative Brown.
Mr. Chairman, thank you. I am sorely confused now. I thought we were talking about, not about us issuing, because we have that. We have those restrictions in place. What I was understanding and the way I read this bill is the exact opposite. This is saying that if somebody drives into our state from another state with a valid driver's license that was issued by another state and they cross our borders, if they didn't follow our rules, they're subject to a fine. How is somebody from another state required to follow our law of issuing our driver's licenses when they live in another state? You just said it was an our issuance, and when it says our issuance, and we're talking about Wyoming, that's not a full faith and credit clause issue. But this bill, as I read it, says, no, we're talking about when somebody else receives a driver's license from another state and they come into our state, if it wasn't issued by the same rules and standards that Wyoming does, they're in violation of this new law that we're trying to implement, and therefore they are subject to a fine. I need clarification on what we're actually trying to do here, because I've heard two stories now.
Representative Bear.
Thank you, Mr. Chairman. First of all, I'll address that last question. So this is dealing with those who cross our borders and have obtained a driver's license from one of the potentially 19 or more states, if they choose to do so, issue driver's license to illegal aliens. So for this to be enforced, the first thing would have to happen is that individual would have to break one of our laws and be pulled over. And then when we run their driver's license, we find out it is one of these licenses that has been issued to an illegal alien by one of those 19 and potentially future other states. Then we would not address that as a valid license in the state of Wyoming. They would receive a fine and potential time in jail for having that license, in addition to whatever punishment they might receive for the other violations that they incurred. Now, as far as well, I'm going to leave it at that. On and for the bill.
Representative Brown.
Thank you, Mr. Chairman. I'm wondering if someone came here from another state and that state said, it's okay for you to drive under the influence of alcohol, do we have to let them drive under the influence of alcohol here in Wyoming?
Representative Provenza.
Thank you, Mr. Chairman. One of the good representatives from the northeast part of the state said that undocumented immigrants have no rights. And I just want to clarify, that is not at all true. This is the greatest country on earth, and we provide protections for the people that come here. Our Bill of Rights, our United States Constitution, signifies that that people have protections. You have your Fourth Amendment to illegal search and seizure. You have many other rights. You have due process. So to say that people that are not documented have no rights, that is a violation of the inherent fabric of this country. And we should know it. We should not violate it.
Representative Ottman.
Thank you, Mr. Chairman. Okay, first off, this bill will recognize and codify under Wyoming law that driver's license documents issued to illegal aliens are not recognized as valid credentials under Wyoming law. It's just to say we have a set of criteria and requirements that people need to meet to get a driver's license. The other thing is that if they do not, if they come from another state that has the same requirements that we do, that they be a U.S. citizen, that they do these things, that they appear in person at the driver's license office, that they get an eye test, that they prove change of name, they have proof of name change, like through marriage or divorce or whatever. If their state, if they meet those requirements, then they can have a license here, and it's also deemed valid in our state. The other thing is that any effort to achieve immigration accountability is worth it. Keep in mind, this is not us requiring a lot of stuff. This is saying that there has been no proof of citizenship and therefore no privilege of driving in this state. It's a federal law of immigration, and that's pretty much, driving is a privilege, and anybody will tell you that in any document will say it's a privilege to drive. And so that is what this is doing. This is not to be a real problem. This is just saying, we have in one of the towns in my county, we have people that are there with no license, no insurance, no tags on their cars, and there's no way to identify them or who they are. So this is just to codify the laws that we already have in Wyoming to meet this issue of illegal immigration.
Representative Bear.
Thank you, Mr. Chairman. Sorry about that loss of mind there earlier. It is getting late, and I will have to admit that some of my worst speeches were giving at late at night. Those are the ones that you get recorded on, folks, and put on the news. So be careful as you get up here late of an evening. But I have finally grasped what it was I was thinking of earlier, and that is dealing with the racial profiling issue. The racial profiling is forbidden on our local levels. All of our law enforcement are trained to stay within the laws and keep our law enforcement agents and their departments safe from legal challenges that would come from racial profiling. So in the state of Wyoming, it's not a state law, but I would welcome anybody that wants to bring that type of legislation. I would be in support of that in the future, but it is a local training and rules and regulation issue for our law enforcement agents, so there's no intent here to create something that conflicts with that. Thank you.
Representative Lawley.
Thank you, Mr. Speaker. I know it's late, but I just a couple of things. I'm, again, still working through the functionality piece, like what happens and then what happens next and then what finally happens. And I have some concerns that the bringer of the bill could maybe talk to me about what do we strand people here in Wyoming if we confiscate their driver's license? What's the next step if ICE doesn't want them? And they have some criteria right now with concerning who they'll take and who they don't want to take. And I don't know if a driver's license violation is going to fit under that. But so I'd like to know about that. And then the other issue I have is we have in our statutes a driver's license compact that we've entered into. So I don't know how that compact works is we have agreed with other states that we will accept the driver's license that are duly issued by their state, and they therefore honor the Wyoming driver's license when we're in their state. I'm wondering about how this compact that's in 317201 and following is going to be affected by this. Are we going to potentially be in a situation where when we drive to a state that we're confiscating licenses of that were duly duly issued by those states, if we confiscate those, is it possible that those states could do the same to Wyoming? Just say we don't honor Wyoming driver's license anymore because you didn't uphold the compact that you agreed to. So that's something I'm concerned about. And again, is the worth it? Is there something that happens that really moves the needle here? And is there a potential downside that we might not have thought about with this compact? So again, I applaud the effort, and I think any movement we can make in this area, that we are limited to what we can do. This is mostly a federal issue, but we do have some things we can do, and I appreciate the effort, but I'm worrying about what do we really get and what might it cost us. And again, I appreciate, though, the effort. Thank you.
Representative Ottman.
Thank you, Mr. Chairman. First off, I will say that as far as functionality, this is a bill to put into law whether or not someone can get a driver's license in the state of Wyoming by being legal or not legal. Okay, as far as functionality, I would say, I don't know. Whatever the state patrol does when they pull people over that have 3 pounds of heroin, what do they do with them? Do they leave them stranded? I don't know. I'm sure it would happen, the same kind of thing would happen. This is not about jerking people's licenses. If we have a compact, which I just heard we do, okay, does the compact agree that Wyoming law should be followed? Nobody said anything about jerking people's licenses. That is not one place in here. And it doesn't talk about consequences. It does say that the rules will be promulgated by the agency. That's what it says.
Question being called. All those in favor of Chairman Knapp's motion that when the committee of the whole rises to report, to do so with recommendation that House Bill 116 do pass. All in favor, say aye. Aye. All opposed, no. No. House Bill 116 has failed committee of the whole. Division having been called, all those in favor, please stand. Oh, okay. Those opposed, please stand. The vote's close enough, we're going to do a roll call vote.
Alamand? Andrew? Angelos? Banks? Bear? Brady? Bratton? Brown Gary? Brown Landon? Byron? Campbell Elisa? Campbell Kevin? Chestick? Clauston? Connolly? Davis? Eklund? Erickson? Filer? Has to come from
Excused.
Geringer? No. Guggenmoss? Haroldson? Haroldson?
Excused.
Harshman? Heiner? Heft? Jarvis? Johnson? Kelly? Knapp? Larson Lloyd? Larson JT? Lawley? Lawley?
Excused.
Lean? Locke? Lucas? McCann? Nicholas? Ottman? Pendergraft? Posey? Provenza? Riggins, excused. Rodriguez Williams? Schmid? Sherwood? Singh? Smith? Storer? Strock? Stivar? Tarver? Thayer? Washut? Wasserberger? Webb? Weber? Excused. Worf? Williams? Winter? Wiley? Yin? Speaker Nyman? Are there any changes? Are there any changes? Closing vote. Vote closed. 34 aye, 23 no, 5 excused.
House Bill 116 has passed the committee of the whole. We've got one more bill to get through, I've been told. So the next bill for our consideration is House Bill 50. Reading clerk, please read the bill.
House Bill 50, sponsored by Judiciary. Disclosure of sensitive information, law enforcement. Mr. Speaker, your committee number 1 Judiciary, to whom is referred House Bill 50, disclosure of sensitive information, law enforcement. Respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Brady, Chestick, Filer, Kelly, Singh, Washit, Webb. Noes, Representatives Bratton, Lean. Representative Washit, Chairman.
You've heard the reading of the bill. What's your pleasure, Chairman Washit?
Mr. Chairman, I move that when the committee of the whole rises to report, to do so with the recommendation that House Bill 50 do pass, and I further move the adoption of the Standing Committee amendment. The bill will be presented and the amendment will be presented by the good Vice Chairman of Judiciary.
Vice Chairman Singh.
Thank you, Mr. Chairman. All right, folks, we're at the end of the night, so we got a nice and easy bill. This is House Bill 50, and what it does is it allows for the Department of Homeland Security to access criminal identification and intelligence information, which, if you want to see what type of information specifically that is, it's found in Wyoming State Statute 9-1-627, and that is information on letter A. So it's information to take fingerprints, photographs, and other information relating to criminal identification, compile reports or other documents in writing containing criminal intelligence information, including statements taken from police, informants, and reports based off investigation and surveillance of suspected criminal activity, and to disseminate and exchange criminal identification data and criminal intelligence information amongst themselves and other law enforcement and agencies of other states. And so this was brought to us from the Department of Homeland Security as essentially an oversight for when previous legislatures were crafting the rules around the Department of Homeland Security. And so the amendment that we made in committee was simply on the very last page, on page 2 and line 15. Instead of making this act effective July 1st, 2025, it's now, the amendment would be to make it effective immediately. For that, I stand for any questions.
Discussion on the amendment. We're on the Standing Committee amendment. Question being called. All those in favor of Standing Committee Amendment number 1, please say aye. All opposed, no. Standing Committee Amendment has been adopted. We're back on the bill. Vice Chair Singh. Any discussion on the bill? Representative Bratton.
Thank you, Mr. Chairman. The state agency that supports security in our homes is involved in a lot of good stuff. Critical infrastructure, cybersecurity, resilience planning, that's prepping, emergency communication, but this is mission creep. My issue with adding this agency to this statute is, unlike the other agencies, the State Homeland Security Director is mandated to share information and intelligence with all federal government agencies and other state homeland programs. That is in 19-13-105 C4. So I have a problem with that. What they're doing within the agencies, if they're talking within our own state agencies, I don't have a problem with that. But this is our state agency, and interestingly, the governor, the statute just before that, that refers, oh, I'm sorry, what do I call him? The head executive. he only has to do it. He's not mandated to do that. So, and this happened to one of my constituents, if a national agency comes to our state or our county and is investigating people who were, say, in our national capital in January a couple of years ago, then our Homeland Security, the director of that agency, she has to cooperate. I would like to change that shall to a may before I add this agency to this statute. So that is why I was a no in committee, and I will be a no on this bill. Thank you.
Further discussion, members? Oh, Vice Chair Singh.
Thank you, Mr. Chairman. You're heard loud and clear, the good representative from the northern part of the state, and if that's a amendment that you'd like to make as we move along with this bill, I'm more than happy to hear it.
Representative Bratton.
Thank you, Mr. Chairman. As much as I would like to make that amendment is in the a different statute that is actually for that agency. And so that can't be changed with this bill. That will have to be a different bill. And if that were to happen, then I would reevaluate on this bill. But it unfortunately can't be done, or I would have brought that amendment. But thank you.
Chairman Washut.
Thank you, Mr. Chairman. So as the director explained to us in committee, this department that's named in the bill is not the repository of criminal intelligence and criminal data in the state of Wyoming. But on occasion, on a need-to-know basis, because this agency has the mission to support us in terms of responding to terrorist events and so forth, that's the mission of the agency. The agency needs to be able to receive criminal intelligence from the division that is the repository of that information, that law enforcement sensitive information. So if a federal law enforcement agency needed information, there would be very little of that information retained by this agency, the agency named in the bill, okay? It's not the repository. And so the standard is when someone asks an agency for information that they've received from a different agency, the requesting agency is referred to the originating agency, the one that is the repository of that information. So yes, the statute says shall, because when it comes to national terrorist incidents, this agency will cooperate with other agencies that are involved in a response to a national terrorist event. Think about 9/11. Do you really want our office to simply say, "Oop, sorry, can't cooperate"? Of course not. Of course not. So this bill authorizes the agency to be the recipient of law enforcement sensitive, need-to-know information on a case-by-case basis when this office has a need. They will not be the repository. Thank you.
Representative Lean.
Thank you, Mr. Chair. I just have a couple of questions about this legislation, and this is why I was a no in committee. You see, if you look to line 4 on page 2, it mentions a department that oversees families. I went and read that statute. It talks about delinquent children. And then when you follow that statute even more to what a delinquent child is and how that delinquent child report comes about in the courts, it gives us an opportunity to see why would that department also need to disseminate information to the one that oversees our homes. I need to know why those two are put in this statute. If we are merely looking to give this agency the opportunity to communicate with another criminal agency, then we need to put it in 1913-105 and silo the information that they can receive. This is my my opposition to the bill as what lists are being created, what are the unintended consequences, and how far does the information being stored go?
Further discussion? Will entertain the question. Question being called. All those in favor of Chairman Washington's motion that when the Committee of the Whole rises to report, do so with the recommendation that House Bill 50 do pass. All those in favor, please say aye. Aye. All opposed, no. No. House Bill 50 is passed the Committee of the Whole. Division having been called, all in favor, please rise. All opposed, please rise. On a vote of 23-28, that bill has failed pursuant to House Rule 6-6B, the bill having failed a voice vote, a standing, okay, we did that. Having failed a standing division vote, a roll call vote is required. The Chief Clerk will please call the roll.
Alamand? Andrew? Angelos? Banks?
Aye.
Bear? Brady? Bratton? 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 Brown Gary? Brown Landon? Brown Landon? Byron? Campbell Elisa? Campbell Kevin? Chestick? Clouston? Connolly? Davis? Eklund? Erickson? Filer? Excused? Geringer? Guggenmoss? Haroldson? Excused? Harshman? Heiner? Heft? Jarvis? Johnson? Kelly? Knapp? Larson Lloyd? Larson JT? Lawley? Lean? Locke? Lucas? McCann? Repeat? Nicholas? Ottman? Pendergraft? Posey? Provenza? Riggins? Excused. Rodriguez Williams? Schmid? Sherwood? Singh? Smith? Storer? Strzok? Stivar? Tarver? Thayer? Washut? Wasserberger? Webb? Weber, excused. Worf? Williams? Winter? Wiley? Yin? Speaker Nyman? Are there any changes? Yeah, please stand. Are there any changes? Johnson, aye. To no. Further changes? Further changes. Closing vote. Vote closed. 21 aye, 36 no, 5 excused.
Pursuant to House Rule 6-6B, House Bill 50, having failed a roll call vote, is indefinitely postponed. Mr. Majority Floor Leader, Mr. Speaker.
Nope, I just got what I have to say. Mr. Majority Floor Leader. Thank you, Mr. Speaker. I move that the Committee of the Whole rise and report.
You have heard the motion. All those in favor say aye. All those opposed, no. Motion carries. Isn't he supposed to? What's that, John? Yeah. The reading clerk will read the Committee of the Whole report.
Mr. Speaker, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. House Bill 47, do pass amended. House Bill 46, do pass. House Bill 80, do pass amended. House Bill 18, do pass. House Bill 172, do pass amended. House Bill 169, do pass amended. House Bill 116, do pass. House Bill 50 failed to pass Committee of the Whole and was indefinitely postponed. Representative Banks, Chairman.
I move. Representative Banks.
Thank you, Mr. Speaker. I move the adoption of the Committee of the Whole report.
You have heard the motion. All those in favor say aye. All those opposed, no. Motion carries. Congratulations, Representative Banks. Messages from the Senate.
Message 108. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 4, State Park Peace Officers, Definition and Scope of Authority. Ayes 21, noes 8, excused 2. Message 109. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 6, Residential Property, Removal of Unlawful Occupant. Ayes 27, noes 2, excused 2. Message 110. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 11, Use of Fraudulent Documents to Wrongfully Possess Property. Ayes 29, excused 2. Message 111. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 25, Electronic Lien and Title System. Ayes 28, noes 1, excused 2. Message 112. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 40, Zoning Protest Petition Amendments. Ayes 29, excused 2. Message 113. Mr. Speaker, the Senate adopted the Committee of the Whole report, failing the bill listed below by the vote indicated. Senate File 14, Wyoming Imagination Library Program. Ayes 6, noes 23, excused 2. The bill has been indefinitely postponed. Message 114. Mr. Speaker, the Senate adopted the Committee of the Whole report, failing the bill listed below by the vote indicated. Senate File 29, Firearm Hold Agreement, Limited Liability. Ayes 2, noes 26, excused 3. The bill has been indefinitely postponed. Message 115. Mr. Speaker, the Senate adopted the Committee of the Whole report, failing the bill listed below by the vote indicated. Senate File 31, Boards and Commissions, Veterans, Ex Officio Members. Ayes 11, noes 17, excused 3. The bill has been indefinitely postponed. Mr. Speaker, the Senate adopted the Committee of the Whole report, failing the bill listed below by the vote indicated. Senate File 21, Ban on Cell Phone Use in Schools. Ayes 7, noes 21, excused 3. This bill has been indefinitely postponed. Sincerely, Ellen Thompson, Senate Chief Clerk.
Thank you. Reader, reports from standing committees.
House Bill 25, sponsored by Transportation, Vehicle Accident Reporting Amendments. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom is referred House Bill 25, Vehicle Accident Reporting Amendments, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Banks, Brown, Geringer, Larson, McCann, Nicholas, Posey, Tarver, Wiley. Representative Brown, Chairman. House Bill 28, sponsored by Transportation, Commercial Driver's Licenses, Revisions. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom is referred House Bill 28, Commercial Driver's Licenses, Revisions, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Banks, Brown, Geringer, Larson, McCann, Posey, Tarver. Noes, Representatives Nicholas and Wiley. Representative Brown, Chairman. House Bill 30, sponsored by Transportation, Driver's Licenses and IDs Revisions. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom is referred House Bill 30, Driver's Licenses and IDs Revisions, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Banks, Brown, Geringer, Larson, McCann, Nicholas, Posey, Tarver, Wiley. Representative Brown, Chairman. House Bill 92, sponsored by Agriculture, Wyoming Livestock Board Memorandums of Understanding. Mr. Speaker, your Committee Number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred House Bill 92, Wyoming Livestock Board Memorandums of Understanding, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Banks, Davis, Johnson, Ottman, Schmid, Strzok, Winter. Noes, Representatives Eklund and Provenza. Representative Winter, Chairman.
Thank you very much. Next, I'd like to have my committee announcements from my committees. Any committee announcements from committee chairs? Representative Heiner, Majority Leader Heiner.
Thank you, Mr. Speaker. Your Committee Number 9 will meet tomorrow morning at 7:30 in Room 5 to hear House Bill 10, House Bill 15, House Bill 59, and if time allows, House Bill 193.
Thank you, Representative Heiner. Chairman Rodriguez-Williams.
Thank you, Mr. Speaker. Your Committee Number 10 will meet tomorrow morning at 8 a.m. in Room 3. We will continue to hear testimony on House Bill 135, autologous and direct blood donations. We'll move on to House Bill 64, chemical abortions, ultrasound requirements, and then House Bill 42, regulation of surgical abortions.
Thank you, Representative Rodriguez-Williams. Chairman Washut.
Thank you, Mr. Speaker. Your Committee Number 1 will meet at 8 o'clock tomorrow morning, Extension Room 1. Here are two bills, House Bill 43, age verification for websites with harmful material, and House Bill 53, governmental claims negligent investigations, starting at 8 a.m.
Thank you, Representative Washut. Representative Knapp.
Mr. Speaker, thank you. Your Number 7 corporations
We'll meet upon new recess tomorrow to hear bills HB 131, ballot drop boxes prohibition, HB 133, sanctuary cities, counties, and state prohibition, and HB 160, voter identification revisions. Thank you, Representative Knapp. Representative Bear.
Thank you, Mr. Chairman. Your committee number 2, Appropriations, will be meeting at 8 a.m. tomorrow morning with the Senate counterpart for a joint appropriations meeting to continue the work on the supplemental budget. We will also be meeting upon noon recess for the same purpose. And then upon adjournment, we will be taking up as a House committee, House Bill 258, the state-funded capital construction, and House Bill 259, supplemental K-12 school facilities appropriations number 2, and any re-referrals as assigned. Thank you.
That clears the deck, Clerk. Majority Floor Leader.
Mr. Speaker, I move that we adjourn until 10 o'clock Wednesday morning, January 22nd.
You have heard the motion from the Majority Floor Leader. All those in favor signify by saying aye. All those opposed, no. Really? Motion passes. Thank you all. And also, that smell you've been smelling is pizza. It's hot. It's in the back there, so you're certainly welcome to it. Thank you, everyone. Appreciate the debate.